for adjournment made on by Mr. B. Talukdar, learned the Michael Curie. Leaves the matter after the vacation.
My lord, I beg to mention, I sent 22 man.
Okay, on the prayer, 22 and 23.
20, yes, John Prayer,
Yeah, for 23. On the prayer for adjournment made by Mr. P.K. Das.
R. Ali.
Huh?
R. Ali,
R. Ali.
on behalf of the children.
No, R. Ali and Mr. Yeah. A. Ahmed. Which is not objected to by the other side, leaves the matter after the vacation. Which is the earlier, which is not objected to.
I'm a brother.
May please, your lordship. I beg to mention item number 3, lordship, with the consent of the other side, lordship.
Yes.
I prefer adjourn that day for that day, lordship.
Who is for item 3?
My lord, I am for the,
Actually, mediation report has to be given.
yes, my lord.
That has not been given.
Yesterday, it was failed, my lord. Yesterday, there was a date for mediation. It was
Okay.
failed,
So the mediation attempt failed.
failed, my lord.
So at least the report will have to come.
Yes, my lord.
Then we will list it. Right. Mr.
KD Sharma.
Your name is
On behalf of KK Dekha, lordship.
KG Sharma.
KD Sharma.
KD Sharma on behalf of Mr.
KK Dekha.
Huh?
KK Dekha.
KK Deka. Praise for adjournment. Full stop. Ms. NS Thakuria appears for the appellant.
Appellant.
Full stop. She submits that the mediation attempt between the parties failed. Full stop. However, the report of the mediation cell has not been submitted. Accordingly, on the prayer of the respondents council, this is the matter after
1 week, lordship.
the vacation.
After.
Next,
Master Grace. I beg to mention item number 14, lordship.
yes, what about it?
Lordship, there is personal difficulties of my senior today, lordship.
Where's your written request for adjournment?
Yesterday we
Huh?
have filed a written request on that.
Item 14?
Yes.
Okay, right, yes. On the prayer for adjournment made on behalf of Mr. B.D. Kowal, learned senior counsel, which is not objected to by the other side, this is the matter after vacation.
Obliged. May please, your lordship.
What's your name?
S. Paul, your lordship.
S. Paul. Heard Mr. S. Paul, learned counsel for the appellant, who submits that the judgment dated 28/2/23 passed by the court of the additional sessions judge Bilasi Para, Dubri, in sessions case number 330/2014, by which the appellant has been convicted under section how many appellants are here? One appellant
One way, lordship.
has been convicted under 302/34 IPC and 201/34 IPC should be set aside. Admit the appeal, call for the LCR, issue notice. Mr.
Didas.
Didas, additional PP appears on behalf of the state. And this is the matter after 4 weeks.
Obliged.
Then there is a IA,
Your lord.
right? Heard, same thing, heard Mr. Swenson, then who submits that this application and the section 389 CRPC should be allowed. And the applicant should be allowed to go on bid. Mr. Swenson, learned counsel for the additional PP, prays for
3 weeks time.
3 weeks time to file written objection. This is the matter after 4 weeks.
Obliged.
My pleasure, Lordship. Here the appellants are convicted.
The other appellant, same case.
Yes, Lordship, under 302.
Acha, is it the same case?
No, Lordship, it's a
The same, different case? Right. Heard Mr.
M. Ahmed.
Learned counsel for the appellant who submits that the judgment dated 25/4/2023 passed by the Court of the Sessions Judge Darang, Mangaldai, in Sessions Case number 9 (DM) close of 2018, by which the appellant has been convicted under section
302/34.
302/34 IPC. And that's all.
No, Lordship, it's and undergone rigor sentence to life.
Sentence is a different thing. Conviction I'm talking about.
Yes, conviction is only under 302/34.
302/34. Issue admit the appeal. Call for the LCR. Issue notice, Mr. Spencer. You are again additional PP accept notice. This is the matter of the 4
Lordship,
weeks.
respondent is also a,
Respondent is there.
yes, Lordship,
Okay.
respondent number 2.
Issue notice returnable in 4 weeks. Then petitioner appellant to take steps for service of notice upon the respondent number 2 and 3.
2 only.
Two. By registered post with AD within 3 days. This is a matter of the 4 weeks. Then heard so and so. This is an application under section 389 CRPC. For suspending the sentence and grant of bail. Mr. So and so additional PP is granted 3 weeks time to file written objection. This is the matter of the 4 weeks.
Well, in this case, Lordship, the objection was supposed to file, Lordship.
File.
They have filed, but Lordship, what happened in this case, Lordship? One of our clerk received this after their filing, Lordship. But we did not receive till today, Lordship. He has not provided to us, Lordship. That
You have
is
not
why
received
I
what?
was under impression that, Lordship, that they have not filed. That is why I could not prepare the case, Lordship. Next
November
week,
22, it has been filed, madam. What do you
honestly
mean?
submitting, Lordship, I informed this matter to my colleague, senior colleague, Lordship. Lordship, next week, any day, Lordship.
No, you take this, you take my copy, yes. You take
Right
my
now,
copy.
Lordship, we could not, 13 witnesses are there, that is,
Huh?
Lordship. 13 witnesses are there, Lordship. That is-
13 witnesses, madam, the witness, there are 2 eyewitnesses, 2 and 5 are there.
Lordship, in that case, next week, any day, Lordship.
Eyewitnesses 2 and 5 are there. This written objection has been filed last year, November. Now it is June.
Lordship,
Then-
my,
No,
this is
no,
my
no,
honest
no,
opinion,
this
Lordship.
cannot be.
Lordship,
Madam, this is too long. This is November.
next week, any day, Lordship.
No.
Next Tuesday or Wednesday, any day, Lordship. Next week, Lordship, kindly accommodate me for the research under 302, Lordship.
Maybe, but
The
eyewitnesses
person
are
is-
there.
he is-
I
Yes,
can
sir.
I can
He-
understand if the filing had been done maybe a month ago and you did not know. This has been filed last year in November, madam.
Lordship, I informed this matter to genuinely to my learned senior.
And for adjournment, you have got to you have got to submit a written.
Inform me in the morning, and Miss Edjan, she dealt with the matter, she is indisposed today, your lordship.
Okay, right.
I leave it to your lordship this day.
It cannot be done. Then. Just 22nd November, it has been filed. No, January 20. January. Filed on January. The IA was filed in November, January. So more than 4 months.
Only last sounds, Lordship.
On the prayer for adjournment made by Miss S.K. Nargis, who submits that she has not brought the file, list the matter on Monday.
Can be on Tuesday, Lordship. Can be
Monday,
Tuesday.
Monday.
Lordship, kindly please Tuesday, Lordship. Kindly Tuesday.
I'm going to dispose of the case. Right, heard Miss
Lordship.
S.K. Nargis, learned counsel for the
Monday.
applicant,
Monday.
and heard Miss B. Buyan, additional PP. This
On
is,
Monday,
this is an application
Lordship,
under
Lordship,
section 389 CRPC
Lordship,
for
Lordship.
suspending the sentence. For suspending the sentence,
Lordship, Lordship, he is
To undergo.
he is paralyzed, the person is paralyzed under the jail. Lordship.
Maybe,
That is,
madam.
Lordship, kindly, on Monday.
on the prayer for adjournment made by Ms. S.K. Nargis, who submits that she has not brought the file, this is the matter on Monday.
Always.
Full stop, just write one thing. It is also noticed that there are two eyewitnesses in this case, that is PW number 2 and 5.
May I please your lordship?
Wait, and just in the main case, you just write. The office note states that the paper book has not been completed by the registry. That's all. Paper book has not been made.
In this case, madam?
Yes.
No, madam.
SC has been received.
LC have been received, there's a missed case, my lord. I have come for the missed case of disposal of the missed case, my lord. I have annexed all the document, my lord, the deposition of all the witnesses. Only, my lord, this petitioner. he has been-
Lordship, live streaming be stopped.
Huh?
POXO matter.
Yes.
Okay, live streaming, stop the live streaming. Dated 21/12/2022, passed by the Court of the Special Judge bracket POXO, North Salmara, Abhayapuri in special bracket P, case number 22 bracket A / 2021, convicting the applicant under section 6 of the POXO Act and sentenced him to undergo RI for the remainder of his natural life with a fine of rupees 50,000, RI for 3 years. No point paying 50,000
In default, lordship to undergo.
if you're already there for remainder of your natural life.
No, there is no.
Anyway, Mr. Didas, the additional PP submits that he has got no objection to the condonation being allowed. Full stop. Next para. On considering the grounds for the delay made out in the application and keeping in view the submission made by Mr. Didas, learned additional PP, the delay of 91 days is condoned. I is accordingly disposed of. Before that, before saying I is accordingly disposed of, we say registry to register the appeal and the connected application
For bail.
and register the same and list the same after review.
All right.
Lordship, this is a application praying for condemnation of delay, Lordship.
How much?
56 days, Lordship.
Yes, but notice you have to go.
It has to, Lordship.
Heard Mr. R.K.D. Chowdhury, learned deputy SGI, who submits that there is a delay of 62 days in filing the appeal against the impugned order dated 23/12/22, passed by the learned special judge, NIA Guwahati, granting bail to the respondent / accused in Miss case bracket NIA bracket close number 46/2022, arising out of special NIA case number 3/2021 in connection with RC-04/2021/NIA-GUW, granting bail to the respondent. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondent by registered post with AD,
By Monday, Lordship.
by registered post with AD on both his present and permanent address. On both his present address and permanent address. This is the matter on, give it.
Uh, Let it be after the vacation,
Yes.
Lordship, 20th July
20th,
20.
20th.
All right.
We'll just get up for 2 minutes. We'll just get up for 2 minutes. We'll come.
Azhar, 14 to time lisa niki? Tension koisa? Paper jo nai mon tension.
last time I directed, why
Salary has not been.
salary is not given,
What is this? Okay, I have not read it. Okay, that transfer order.
Yes, yes, after the state, but state, he has applied for leave for 3 months, though he applied at the Kasha, his application was transferred to Dorang division, and accordingly, I have annexed in the last annexation number 8, page 44,
Just a minute, just a minute. Just a minute.
3 months salary.
Yes. So,
He has applied for leave for 3 months. And accordingly, his leave salary was paid, page 44 annexure 8, up to October, November and December 2022.
page 44.
44 last page, of the requisition, 2,74,524 has been paid as leave salary for the month of October, November and December,
Huh.
Subsequent to that, he has never applied for any leave, there
He has never applied for?
for any leave and never went, as he was transferred, he has never applied in Dorang, never applied in Kasar also. Earlier he applied in Kasar, though he was transferred to Dorang division, he stayed in Kasar division, he applied for leave for DR. Subsequent that application was transferred to Dorang division. And this order of page 44 is of.
No, but then how can he apply? Because if he applies from Darang, then it will amount to accepting the transfer.
This leave application he applied in Kasar division.
Okay.
It was transferred to Dorang.
Ah.
And from the Dorang division, page 44 from junior superintendent post office Dorang division allowed the leave salary. Subsequently, he has neither applied in Kasar, neither applied in Dorang also. Yes,
Because
never-
again you send it to Darang.
Yes, neither applied in.
Okay, that is, so what is the case?
He has done work also, do not do any work and don't apply for any leave also, So, that's why this, that is the instruction, One thing is that, I do agree, there are little bit fault of the department also that, in spite of that order, stay order, and the release order also stayed by the CIT, Lanak CIT, but subsequently only we have filed the MA, miscellaneous application for vacating the stay order. That was not considered totally, my lord. They filed a contempt, and that was direction after direction. And subsequently, my lord, only these 3 months, and my lord,
And you consider his case, he's retiring next year. When are you retiring?
no. Well, fact is, that, he joined in the Kasar division on 9/6/2016.
9/6/2016, no.
16. His tenure, 3 years tenure completed, and he is a assistant superintendent, next second hierarchy in the division. Is a all India transferable job. His transfer order 29/9/2020, more than 3 years. Then he applied as because in the midterm of this son's exam. That is also over in the meantime. In the meantime, that COVID situation start, and no division bench in the CAT. Because of that, we filed somehow lately that MA. But that was not totally considered by the Lanak CAT that MA is kept in bench.
And this tribunal is going to decide the matter when? September?
On September, yes.
September,
That
4th
may be, that direction may be given by this honorable court, spirit
Dispose
direction.
of the matter within a period of one month, my lord. That is also.
No, within a
because
matter of
matter
2
is
weeks.
already fixed for a year.
Within a matter of 2 weeks.
Either
Yes, yes.
otherwise, regarding only my one submission is that yes, he has no right to stay diya
Correct.
and regarding this
Let the tribunal decide the matter.
and but regarding this period that shall I
That is not an issue here.
yes
No,
Yes,
we just. Okay, right. You see, you just take. Last order, para 1, 2, 3, 4, 5, 6. Para 7, huh? I think, what is your son studying now?
Lordship? No. His
not-
exam is already over.
What is he doing now?
Most probably he is doing engineering at present. I'm not sure, my lord.
that
Right,
time
the petitioner's counsel submits that the learned tribunal has fixed, which date?
My lord, date,
Which
Uh,
date?
4th September 2000.
Has
Four-
fixed
four-
4/9/2023 as the date on which hearing would be held for disposal of
OA 222
OA number 222/2020
as well as CP contempt
as well as
CP and MA, my lord.
as well as CP number 10 of 2022 and
2021.
MA has already been heard.
No, MA dispose of CP 10/2021, my lord.
CP number 10 of 2021.
Yes.
That's all I think.
Yes.
Good, sir. Next, Mr. K. Parasad. No, first off. Mr. K. Parasad, the learned counsel for the petitioners, submits that the respondent has got no right to remain in Kachar division as he has been in the said division since 9/6/2016. He also submits that as the petitioners post the respondents post. As the petitioners posting is a transferable one, comma. The continuation of the respondent in the said post. And in the chart division for such a long time is not proper. Full stop. He also submits that. No, that's also stuff. He submits that. The issue is urgent and the date of hearing fixed by the learned tribunal may be interfered with and a shorter date be fixed by this court for disposal of the above cases by the learned tribunal. Next para, the learned counsel for the respondent does not have any objection to the submission made by the petitioner's counsel for fixing a date for disposal of the above cases by the learned tribunal. In view of the consent of the parties, this writ petition is disposed of with the direction to the no, it is disposed of. Can we direct the tribunal?
My lord, as early as possible, my lord.
In view of the consent of the parties, comma. It is hoped that, anyway, the appeal lies here, no?
Yes, yes.
It is directed that the learned tribunal shall. It is directed that the tribunal shall dispose of OA number 222/2020 and CP number 10 of 2021. Pleadings are complete.
Yes, my lord.
In view of the pleadings being complete in both the cases. At the earliest and preferably within a period of 3 weeks from the date of receipt of a certified copy of this order. Copy of this order, let's say copy of this order. The writ petitions accordingly disposed. Take it 3 weeks.
Deeply.
Who is the additional PP here? You're the one from beginning.
I am appearing for the informant.
Huh?
I am appearing for the informant.
Informant. Yes,
My lord, may I please your lordship, my lord, in this case, there are two appeals, my lord. One is criminal appeal number 359 of 2017. That has been filed by one Abdul Malik.
filed by
One
informant
accused
is
appellant, Abdul Malik, one convict,
Abdul Malik.
Malik, M-A-L-E-K. Then the second criminal appeal is criminal appeal number 362 of 2017, wherein 6 accused appellant has filed the appeal, my lord.
No, in 359, how many accused are there?
My lord, same common judgment, they have filed separate appeals, my lord, one judgment. While preferring the appeal, my lord, one judgment. Two appeal has been preferred, one by one person and one by 6%, my lord.
So in 359,
Yes,
who is the appellant?
Abdul Malik.
Abdul Malik. And in 362,
362, there are 6 accused appellants, my lord. Shall I give the name?
6
Yes.
accused. No,
Yes.
6 accused.
Yes, my
appellant.
lord. That your lordship.
So
will-
all these 7 persons
Yes,
They were the accused in both in
Yes,
the
yes, yes.
trial
In
court.
one.
Was
case,
there
one-
any other accused in
No,
the,
no.
only this?
Only this.
So altogether, 7 accused were
Yes,
there in
Yes,
the trial
common
court.
judgment
So all of them have been convicted.
convicted, my lord. But here I'd like to point out, so for accused appellant number 5 of criminal appeal 362 is concerned, my lord.
Appellant 5.
Yes, my lord. He expired during the trial, my lord. So against him, I think it will stand abated.
If he's, then why did you file an appeal? If he
No,
died during trial?
Pending appeal, he died. Appeal was filed when he was alive. In the meantime, he died. It has been brought to
Pending
light
appeal, you mean after the appeal was filed?
after appeal was filed. Pending hearing of the appeal, my lord. The person has died, my lord. So there is an order to death, Saisila order.
Police report is there.
Police report is also there, probably order is also there.
So what is this case about?
Yes, my lord. So here, before going to it, my lord, I'd like to point out certain things, my lord. Then we'll proceed with the case of the prosecution case, and I'll open my case, my lord. So here in this case, 7 accused faced a joint trial under sections 147, 148, 302, 323, and 324.
302, 323,
324, 147, 148, read with 149 CRPC, IPC. Unlawful assembly and common intention. So, my lord, so for 323 and 324, the concern, they have been acquitted. It could
so
not be
3 acquitted under 324,
324, 323.
So convicted under 302,
Basically on the 302 with the aid of 149
149.
and unlawful assembly and rioting 147, 148.
So the 3 separate sentences and
Yes,
conviction.
absolutely. So, my lord, here in this case, the FIR, my lord, which is the genesis of the prosecution case, my lord, page 4, my lord, your lordship will see that whether this can be treated as, my first law point will be that whether this FIR can be treated as a legal and valid FIR.
FIR dated
My lord, this is dated, what date is 16/2/2012, my lord. It was registered at 6 PM, my lord. Shall I read, my lord, page 4? Well, this informant is one Karimun Nesha, officer in charge Sorbuk police station, subject Azahar. Informant Karimun Nesha. She is the wife of the deceased and she is said to be an alleged eyewitness of the case.
PW
PW1, my.
informant is PW1.
Yes. Wife of the deceased. And she alleged to be one of the eyewitness, which I'll try to say that she was never an eyewitness and not present at the place of occurrence. Deceased is late Kader Ali, my lord, the husband of the informant. My. So I read, my lord. Accused Shahjahan Ali, Abdul Hai Toibur, Malek, Gofur, Abbas, Abdul Haq, and others. And date of occurrence is 6/2/2012. Place of occurrence Sapur, and time of the occurrence was 8 AM. Your lordship will kindly keep the date and time on mind, my lord. 8 AM occurrence took place, and this FIR happens to be lodged at 6 PM in the evening, my lord. So there is a clear-cut delay of 10 hours, my lord, which in this type of cases becomes fatal, my lord. Per se, it may not be fatal, may be busy with treatment, may be busy with funeral and all this thing. But the facts remain, my lord. The other emerging factors are there, my lord. I'll take it to your lordship one by one.
But this is in a village.
Yes, my lord.
How far is the police station?
Here it is, your lordship will find at page 2, my lord. Page 1 itself, yes. Normally they write, my lord, but here it seems it has been all kept vacant, my lord. ₹5 kilometers, my lord.
5 kilometers.
And there are other attending circumstances which will show that they were present in the police station at that railway. Anyway, the page 5, my lord. The informant has the honor to state that about 11 years ago, the informant purchased a plot of land measuring 1 bigha and 10 acres situated towards the north of the house of her husband from the father of accused number 1, 2, and 3. That is 1, 2, and 3 is Shahjahan Ali Abdulhai Toibur. That is late Ataur Fakir's sons, my lord. She has purchased or they have purchased the land and have been possessing and enjoying the same since then. The aforesaid accused person had been trying to dispose of the informant from her land and to kill her husband since before. That around 8 a.m. on 16/2/2012, when the informant husband was going to attend mail. So your lordship will take kindly note of it, my lord. The variance will come subsequently, my lord. So I'm requesting your lordship to take note of this line, my lord. Husband was going to attend mail, that is meeting, my lord. At a little distance from his house, the aforesaid accused person in a body, armed with dagger, dao, spear, and other sharp weapons, harassed the informant's husband Kader Ali near a pond and attacked him in a planned way. Accused number 1, that is Shahjahan, my lord. Stabbed informant's husband below his chest with a dagger he carried, as a result of which blood gushed out from his body and fell down unconscious at the place of occurrence. So a single blow was given, my lord. When the informant came to the place of occurrence to offer resistance, the accused person assaulted her on his right hand with dao, dagger, etc. they had carried and thus caused grievous injuries to her. So I'll just pause for a moment and say why they were acquitted. Because of this facts as was never proved. 323 and 324. This part of the assault. Because your lordship will keep it in mind, they are injured witness. In spite of that, court acquitted this accused person. Because these facts were subsequently cannot be proved or it was false or whatsoever. They also hacked informant's brother-in-law Soidul Haq with a dagger while he was passing by the place of occurrence. This is also not true, though they were charged. When the witness and neighbors came to the place of occurrence, the accused person left the place of occurrence, supposing that the husband of the informant had died. Later on, all of them were admitted into the hospital in the moribund state. Since condition of the informant's husband deteriorated, he was first taken to Sorbog Hospital, then to Borpeta Hospital, then to Bohanga Hospital, therefrom, where the doctor declared him dead. The informant's brother-in-law is undergoing treatment at Borpeta Hospital. That is PW4, that brother. But all the charges, no materials were found. It is by the same set of evidence, my lord. Not two set of evidence. One set of evidence, it would not be distinguished, my lord. So it is therefore prayed that your honor will please to investigate the case and error. Now the case happens to be registered on the same day at dated 6/2/2012 at 6 p.m. 16/2/2012 at 6 p.m. And the occurrence took place at 8 a.m. So if your lordship will kindly turn to page column 8, my lord, of the FIR, my lord, there is a column that if reasons for delay in reporting the complaint and the informant is to be taken note. Page 2, my lord. This is kept vacant, my lord. Why there was delay, the police normally ought to have taken note of it. Now your lordship will see that why I'm saying that this is not an FIR. Because of the fact, my lord, that police came before this FIR was lodged, inquest was conducted. Police came before by making GD entries because information was already given, my lord, to the police. Police comes out at 9, they reach the place of occurrence. At 8, they receive the information, they makes a GD 470, my lord. And thereafter,
So
they come Yeah.
where is that? GD
116, my lord, exhibit 5. Yes, my lord. Extra, this is exhibit 5, my lord. Extract copy of GD number 470, 8 AM, receipt of information of assaulting with Dow, Digger and entry. Now one Fazal Haq. This person was never examined during investigation and also during trial. Who is this Fazal Haq, my lord? Of Sapur informs of a phone that following argument between two members of two families with regard to certain land, they have entered into a fight being armed with Dow dagger, that two persons.
So how does it matter?
It matters, my lord.
How?
Because the story given by them are the interested version. And this is the natural version, and the police comes out and technically when an information is given disclosing a cognizable offense under section 154, then that case should be treated. Subsequent, 1 minute.
No, there was a fight.
Yes,
There was a fight,
Yes.
someone died.
yes,
Then
absolutely.
what
That is
wrong?
my case. That is my case. There was a mutual fight maybe. So it was a free fight for all. Who with whom with what, we don't know. That evidence was never laid. One version of the story has been laid. What was the genesis of the prosecution case? They have come up with a theory that we have been assaulted. It's not that way. And that two person was lying there. Where did the other person vanish? If the police comes at 9 o'clock, finds only one person. Who's that person? Where is that investigation? Nothing. If your lordship will compare, this is the information received at 8 immediately at the time of occurrence. And this is 9.10, the other GD entry pertaining to 473. When the police comes out and takes note of the situation. The law. Yeah, list of books नहीं दिया। अबे list of books देना तो काम करना। किताब citations.
Yes.
So, my lord, now first we will complete exhibit 5, my lord. Be the members of two families with regard to certain land, they have entered into a fight being armed with Dow dagger. The two persons are lying injured in the field and that police should visit the place of occurrence. Accordingly, I make the entry and instruct ASI D Talukdar to go to the place of occurrence. Now, D Talukdar comes out, my lord, by making a GD entry and he says what he has found at 9:10. Departure of SI and staff entry. Now, SI D Talukdar, who had gone to the place of occurrence in connection with GD number 470, exhibit 5, dated 16/2, informs over phone that a person, when he goes, then one person has been found lying injured at the place of occurrence, that blood is coming out from his entire person, and from his, that he is struggling for his life, and that situated, and the situation at, it should be, my lord, and that the situation at the place of occurrence is very tense. That's wrongly typed probably. On receipt of information, I directed SI DS does and staff to proceed to the place of occurrence, whereupon they proceed to the place of occurrence. So my respectful submission, my lord, now if your lordship will see the inquest and all other things, my lord, were done at the time, my lord, because they were taken to the hospital, my lord. My respectful contingent will be this, my lord. If your lordship will kindly turn to page 103, my lord. By 103, my lord. This postmortem examination is done not on the basis of the police case. It was done on the basis of Sorbo PSGD number 16-2. If your lordship will see on the top postmortem, a reference Sorbo PSGD number 470 dated 16-2-2012.
Postmortem report dated.
My lord, dated is, they have done it on the same day, my lord, but it shows it is 18 February. The report, but date and hour, it was 16-2-2012 at 3 PM, bottom, my lord. It is signed on 18, my lord. If your lordship will see the particular date and hour of dispatch, 16-2-2012 at 3 PM. Arrival at the date house 16-2-2013 at 3:30. Examination that is started time is 16-2-2030 at 3:30 PM.
Arrival at dead house, what do you mean?
My lord, when the dead body was brought in the morgue, brought. So now, from the postmortem, if I show, my lord, that this is one aspect, my lord, and one single injury in the chest was given. The way they projected in the FIR that as if mass hitting and mass assault was done, my lord.
Why not?
Why,
Maybe
my
it
lord?
doesn't show.
Medical story completely belies it. Even I'll show, my lord, how they have manufactured the case, my lord. Because if they are saying that I have bitten back and blue, my lord, so there will be many injuries, but only one injury was found. So the narration that is being given, my lord, is an afterthought narration, which I'll try to.
So you mean to say 149 is not attractive?
No, I'm not at all. And these eyewitnesses, there are actually 4 eyewitnesses, 2 eyewitnesses directly on the point. Others are all alleged eyewitnesses. And these 2 eyewitnesses are also doubtful now, my lord. That is my response submission. I'll take, this is one legal aspect which I'm arguing it, my lord. So if your lordship will ask me what is the legal position for this, my submission, my lord. So we have got a judgment from our High Court, my lord. When the investigation starts, when the police comes out to the spot, verifies the spots, asks people, makes some investigation like doing the inquest, postmortem and all this thing, then it is said that, my lord, the investigation has started. On the other hand, my lord, if the information disclosing is a cognizable offense, wherein the police need not wait for the formal FIR. Merely coming out to the spot by registering that, if it is a cryptic response, my lord, from over phone, my lord, then it cannot be treated as an FIR. I say for an example, that Mr. Police, please come out, there is a fight going on. And the police comes and finds a dead body. That information may not be an FIR, my lord, though he has come out. But if that same person say that A is assaulting B and he has died, that is a cognizable offense. So that GD will be an FIR, my lord.
But this GD does not say that.
This GD says, my lord, that
where
there is a market. If your lordship sees. I read again for your lordship's kind perusal, appreciation. Now on Fazal Haq over phone that following arguments between the members to family with regard to certain land, they have entered into a fight. Being armed with doubt, dagger and 2 persons are lying injured.
He is just giving some information.
Yes,
It doesn't-
information
it-
disclosing a cognizable offense.
That doesn't mean that it has to be an
No, my
FIR.
respectful submission will be that your lordship would accept.
No, we are just, you see, we are
Appraising
being
your
allowed
lordship.
so that you have to address our
Absolutely,
concern.
absolutely.
That's all.
Right.
Not that I want to argue with you or anything. It is that
Not
we are
that way.
having the cobwebs that we will be having, you'll have to clear it. That's
No, no, no. We are just trying to place upon what we understand the law, my lord. Maybe my understanding may be wrong, I don't know.
No,
my
no,
lord.
but basically what you're trying to say is that this should be treated as the
And
FIR.
FIR. Now, if your lordship will ask me a question, my lord, then what happens to that FIR, my lord? That FIR will be hit by 162, my lord. So that will be a subsequent statement. it cannot be an FIR. And in any case, your lordship knows it very well that FIR are not substantive piece of evidence. Ultimately, evidence has to be laid and proved. Then only the case will stand. And this is the legal proposition. For that, my lord, first one judgment. I'll give two judgments. One from our Guwahati High Court and one from our Guwahati High Court going to Supreme Court, my lord. That also. I'll give both sides of the verses, my lord, how it is to be treated, my lord.
Then the FIR should be treated as a substantive statement. What is-
Substantive. लेकिन मूल हो ना तो घास हुआ है मुंह तक नहीं Madam, I'm sorry, madam, my junior did not read the second piece of. Just referring, madam, I'll give the list of books, madam. 2010 Criminal Law Journal 781, Guwahati High Court, Division
2010.
10. तुम्हारे असेल 2010 CRLJ 781, Guwahati High Court, Agartala Bench. Yeah, right. Well, I'm sorry, Mala, having one copy, Mala. Goes to that one. Page 20, para 25. I'm sorry, Mala, we have made one copy. Division bench matter. But actually, it will be from para Twitter. If we want to know the deeper thing, my lord, it starts from para 22, but the ratio has been laid at
22.
para 25, my lord.
From 22 to 25.
Yes, my lord. Ratio is at para 25. পঠাই দিয়ে না দিনের ফটো ফটো করিলো এগুলো কিবা পড়া ভাই এদিনও মতো মই কি কব লাগে ভাই কিন্তু অলরেডি উল্লেখ করছি মই তোমার কাছে কখন করতে বুঝতে
Yes.
This is one way of looking thing, my
No,
lord.
please,
Another,
please read it. Please read it. It becomes difficult for us to.
Oh,
There's
yeah.
only one copy.
my
So,
lord,
you see,
I'm sorry, my lord.
Very difficult to both of us.
Only, sir.
You may read the relevant paragraph.
Yeah, my lord, my lord, my lord. My lord, I'm reading from para 22, bottom 3 lines, my lord. Before this written information which has been taken and recorded by the learned trial court as the first information report
Where are you reading?
was para 22, my lord,
22.
left hand side, was received by police. The investigation have already commenced. It becomes abundantly clear
Yes,
that
sir,
notwithstanding the
We're not getting it.
para 22, my lord,
We've got it in front of us, para 22. Where are you? Where is this before?
para 22, there is a break, my lord.
Yes, there's a break. Yes.
Satyendra is the word.
Yes. Okay.
Before this written information,
Acha.
which has been taken on record by the learned trial court as the first information report was received by the police, the investigation had already commenced. It becomes abundantly clear that notwithstanding the fact that the police, the prosecution, as well as the learned trial court has treated Exhibit 1 as the FIR, this Exhibit 1 could not have been legally treated as an FIR. Inasmuch as the FIR was lodged after the police investigation had already started, inasmuch as the police, on being orally informed about the occurrence, had already visited the place of occurrence and held inquest over the dead body, the contents of Exhibit 1 could have therefore been used as based as statement of PW1 made during the course of the investigation to the police. A careful analysis of the scheme of the CRPC clearly shows that when any information relating to commission of a cognizable offence is given to an officer in charge of a police station, it is the duty to reduce such information into writing, to get the information reduced into writing, read over to the information, so reduced into writing to the informant, and then the information, whether given orally or in writing, shall be signed by the person giving the information, and the substance thereof shall be entered in the general diary, as state government may prescribe, see section 154. So this is the process that has been laid, my lord. So I would like to skip 24 and straightway go to the ratio, my lord. But I would like to point out, my lord, for this, my lord, the case per se will not fall, my lord, but one of the factors to be taken into consideration. Because ultimately, the evidence that will be laid in the trial is the substantive evidence, my lord. But I am showing one of the
No,
factors.
you're basically saying that investigation started prior to the FIR
Yeah.
being registered.
So they got a,
So
good
this has to
time.
be read as a statement.
yes,
Now, if it is not done,
it
If
will
it
not
is-
be that fatal
then
that
now-
that my whole case will rest on that and I will win. No, my lord. Because I am trying to impress upon your lordship that they have got sufficient time to maneuver things, manipulate things, afterthought, improvisation and all these things, appearing vis-a-vis the evidence on record. So what was the genesis of the prosecution case? As per the GD entry, two groups fighting over the landed property, my lord. And the informant also say in the FIR, my lord, that regarding land, they were trying to.
was the GD entry exhibited?
Yes, my exhibit 5, my.
Five.
Five.
That 470.
Yes, ma'am. And 5.3 is the steps taken by the police, madam. My thrust of argument on this point is that, my lord, that for that the whole case I will not win, my lord. That is for sure, my lord. But that is a vital factor which your lordship will take into your lordship consideration while evaluating the evidence as to how they have them. So that's why in the form at column 8, my lord, there is a column, my lord, that if a person is delaying in the FIR because the Thana was 5 kilometers, they comes to the police station with the dead body. Also at that time it was not FIR was filed. They goes home, makes the funeral arrangement, burial. Thereafter this FIR took shape. That is my respectful submission, that it is an afterthought plan and maneuvered FIR.
When did he die? When did the deceased die? What time?
My lord, at 3 p.m. at hospital, my lord. Then the evidence that has been laid, my lord, by the other witnesses, my lord. Other witnesses, that the dead was brought to the PS, my lord, and with arms that were they found it at the place of occurrence, they deposited the arms that were seized, my lord, which cannot be treated as recovery, my lord, under section 27 or whatsoever, seizure also, because the other side has produced those arms. So that I dealt with it, my lord. But now at that time also, the police did not record the FIR also. Their evidence is there, my lord. I'll show it one by one. But first, I would like to address this point. So, if your lordship permits me to para 25, I'll read. Then I'll say what the Supreme Court also got to say of this time. Because this type of thing, basically, my lord, I have personal experience as a PP, but many a time we have to face this situation, my lord. That Assam police still believe that until and unless a formal FIR is not lodged, they cannot take up that case. That is not a correct proposition, my lord. Lots of trial was given to amend things, but it never happened. So the Supreme Court has also one case going from Guwahati High Court judgment, my lord. That was also treated. That is against me, but fairly I place it back. That what Supreme Court has got to say in this type of situations, my lord. Because my duty to. point out
Against
also-
you, but now to your advantage.
No, my lord, right now I'm using it, my lord. But I'll show that also, my lord. In fact, in fact, I have cross-marked it, but my conscience say I should point it out. I'll point it, my lord. But just a moment, we'll go to para 25. Because this is one proposition, and there is another proposition from Supreme Court, Sambuda's case. My lord. In present case too, when on the very night of the occurrence, oral information was given by PW2 to the OC Selema PS. It was the duty of the officer in charge of the state police station to reduce or to get reduced the oral information so received by him into writing. The officer in charge, however, failed to discharge the statutory obligation. This apart, without reducing the oral information given to him into writing, the officer in charge of the state police station entrusted another police officer, same like us, to investigate the place of occurrence and examine the place of occurrence, drew sketch map, held inquest over the dead body. As this stage when he received information in the form of the FIR from PW1 at the place of occurrence, such information, this is the ratio, could not have been treated as FIR in as much as investigation had already commenced, and hence the said information could have at best be treated as a statement made by PW1 to the state officer during the course of the investigation of the case. So at the base, it should be a 161 statement, which in any case is for corroboration, contradictory purposes. So same also in the FIR, my lord, we can contradict it, that your story is not correct. Now, if I lodge it, it will already go.
But in any way, the FIR, says
Yeah.
that FIR it doesn't have any value. Does it have any value?
See, actually, your lordship knows it very well that FIR is the launching pad of the prosecution case. It just keeps the ball to roll, my lord. But it must disclose a cognizable offence. Once a cognizable offence is disclosed, that becomes the FIR. If it is a cryptic information, my lord, as the Supreme Court has said in Sambuda's case, my lord, that it cannot be treated as FIR. Similar thing which this case, Sambunath from Guwahati High Court went to Supreme Court, my lord, so Supreme Court has to deal with that part of the aspect. My lord. So that I'd like to place it. One copy. We have Asana Amana.
Yeah, thank you.
Go to.
What is it? Only one copy.
Sambuda has to do now. What did you do? According to my-
I think you should bring two copies. I
Yeah,
mean,
my lord, definitely, my lord. My lord, I'll prepare case or I'll prepare a copy, my lord, my junior. Unfortunately. No.
We can understand, okay, one or two judgments you have forgotten, but if you have all of them as one copy, then
Sambudas.
how many judgments are you going to rely upon?
My lord, not much, my lord, six.
Six. You have got two copies, you
My
know.
lord, I'll get it, my lord. In the break, I'll get it, my lord. Now I'll be ready, my lord. Because
You see,
everything we have to
it's
do, my
not-
lord, then it
it's
becomes
not-
difficult.
You
That
see,
was
so
the
that
point
we
of-
can all read together.
Yeah, my lord, absolutely.
You see, it's
Do
not
that,
that
my
you
lord.
give us later on, that
Yeah.
even
My
we
lord,
can
I
get it
apologize,
later
my
on.
lord. We are bound to do that, my lord.
No, it's not that. I'm just saying
No,
that,
no, my
you see,
lord,
when you're submitting,
No, otherwise.
so
my
that we
lord,
can all read together.
absolutely, absolutely.
Otherwise,
I do
you give us
apologize.
later, we can also get it later. That's not an
Absolutely.
issue.
No, my lord.
We'll rest for 2 minutes.
My lord.
তাকেতো একোৱে নকৰে ভাই মই যদি চব কৰিব লাগে জুনিয়ৰৰ কি লিষ্ট অফ বুকস মোক আগে দিয়ক না বড় সাহেব মোক ফটো স্টেট কৰাই আনি দিয়ক ন এটা মোক লাগিবতো আপোনালোকৰ নোলাই নেকি এইটো দি দিয়ক না কি একো নকৰে এইটো তুমি DLR আহিছে না গোটেই কেইটা আছে এইটো আকৌ প্ৰব্লেম হ'ব এইটো মূৰটো এইকেইটা দি দিয়ক এইটো হৈ গ'ল আপোনাৰ প্ৰব্লেম হ'ল এইটো বুজি নাপায় মই ৰেফাৰ কৰিছো CRL না থেৰাপি নিমিলিব নহয় আপুনি আনিছে GLR এইকেইটা গোটেইকেইটা আছে লিষ্ট অফ বুকস টো লেট ভাই একো দিয়া अरे भाई आगे लिस्ट ऑफ बुक्स এখন বনোৱা না তোমার যদি পড়ে মই বনাই দিই সিরিয়াল নম্বর দিয়া লিস্ট অফ সাইটেশন কি দিয়া শম্ভু দাস তো পাইছে নাকি না যেটা ভালো দাম জানা পাই শম্ভু দাস তো দেখো
You see, Mr. Kamar, as we were just thinking,
for one point I'm dealing my lord rest I'll make myself
no, you see, we were just thinking,
my lord
maybe we'll adjourn the matter when you have got a double
No,
set of judgments.
normally actually after conclusion of the evidence we place but here the law point is straightway I'm taking up that's why I'm pointing well this is one book it is শম্ভু দাস No, it was just for a moment, in the second half, I'll synchronize everything. Take it up on video. This is one of the judgment dealing with the telephonic information given by the. This is Supreme Court, my lord.
What about this? Not that.
This is Shambhu Das,
You see,
2010 SCC.
I'm sorry, Mr. Council. I think You should have two sets.
Yeah, my lord, absolutely.
Yeah, I think you've now taken us through a few judgments.
Yes, no, no, I'll not.
All
now
one
cite, my
copy
lord.
only. I think we will adjourn the
My
matter.
lord, thereafter,
You bring two copies.
my lord.
One, two matters, one, two cases, okay, but not
Please, sir.
everything. This is not the way.
Yeah, right, absolutely. I apologize. That is sure, my lord.
All right.
My lord, actually, we put the judgment at the last, my lord.
No, it's okay, but then it's not, you were referring to judgment, you have
Yes,
given a judgment, but only one copy at
I
a time.
only take it on myself,
Yeah.
though it was the task of the junior.
Correct,
I'm
correct.
taking it
You
on my
have
own,
got
my
to
lord.
tell,
I
because we
apologize.
cannot allow this to continue as a normal routine.
Sure.
One or two judgments, okay, you make a mistake, it's okay, but not all. Right.
My lord, now I'll not cite citation, my lord, I'll go directly to.
No, you see, one thing is that with citation, it helps because as you are doing, that's correct. I mean, it's easier for us to understand also. Because you give us all the points at one go and then you try to relate it back to what you said by judgments at the end of the day. It takes a little bit more effort on our part to understand also.
Sure.
So for you, it'll be easy because it's your case. Only problem is that next time, please give us two sets of judgments, not one set.
My lord, that's so.
That's all.
Well, actually, by burning midnight oil, we'll prepare the case by the, but something is to be done by the assisting counsel.
Correct.
We are focused more on the case by.
You see, this adjournment is nothing against you.
Oh.
It's just that it becomes difficult for both of us.
Yeah, right.
Because I want to make some notes, he
Yeah.
also wants to make some notes.
No, ultimately, your lordship will write a judgment that has to be in consonance with the law.
Yeah.
my lord. And I am also trying to place, my lord, what is also appearing maybe against me. We don't know.
No, it's okay. Even, anyway, my brother also made notes, I have made
Oh,
notes.
yeah, sure, my
And then it becomes difficult when we read the judgments.
lord. My lord.
One judgment together becomes difficult. So it doesn't matter.
My only.
When do you want?
My only prayer to your lordship is that they are on bail and this is matter of 2017 lordship.
2017, oh,
Therefore, a short date may be fixed, lordship. That is all.
no, as long as they are, we are ready, we are not running away from the case. Only thing it becomes difficult for us.
My lord, he is trying to put me behind bars, but he's not thinking that if I get acquittals, what happens?
Yes, he may get acquittal. I am not on that. He may get acquittal, he may get convicted. But my only prayer is that this matter may be.
But I'm ready, my lord, because of this
Dispose of
technical
matter,
aspect.
that
If
is
your
my
lordship
prayer.
takes up at two. For me, no issue. At two, I'll come prepared.
Any date. I am
No,
not,
today
but
itself,
only a
at two.
fixed date. I am praying, lordship.
No, at two, let us start. We can start at two. I'll come prepared with all the citations, my lord.
It depends. We
Provided your lordship accommodates.
can do it at 2 if you all are ready.
I'm agree.
We can do it at 2. No problem.
We'll come back at two, my lord. Your lordship will kindly be here for a moment, my lord. Bye. Hi. Mal. I'm
Next.
sorry, Mal.
No, not
Oh,
really.
my lord.
We
No,
don't
but
want
it
it to become a
embarrasses us
normal
also, my
practice,
lord.
that's all.
It embarrasses us also, man.
Take this government.
17 to 19.
What about 15, 16?
15 is over, at
Huh?
2 p.m.
Oh, this is 15 to 16.
Yes, my lord. Before going into the matter, now 17, 18, my lord.
Ah.
There is a one dates reference connected to,
How much time will you take?
well, there is a one issue that's creating some doubts on my mind. Because there are two criminal appeal by the same convict, my lord. Same person.
That cannot be. Can it be done?
No, my lord, what happened, my lord? In the item number 17, it is a death reference, my lord.
Okay.
And the relating to the death appeal is the 18, my lord. 18 is his appeal, my lord, and 19 is another appeal of the same accused, where he's been convicted for life. For another
Two different cases.
two different cases.
So this will have to be taken out.
So my lord, what is my contention is, because this is a death sentence. So lordship has to decide on the sentence part also. First of all, because it's a death reference.
Correct.
So when it is a death reference, the one is the aggravating circumstances maybe about the second case, where he's been convicted for the life in the same transaction. Transaction is same, this incident is the same, but the offense is the two different lady has died. So
Two ladies.
two lady died in the similar kind of a nature of an accused. Accused is the one, same accused. Now he is convicted in one case, the death reference, death. In the other case, life. Now, when will death reference comes, my lord? So lordship will not definitely see whether the death can be imposed or not regarding the sentence part. So while deciding the sentence part, lordship also has to see, is there any aggravating circumstances against him? The aggravating circumstances as of now is the criminal appeal second one, where he's been convicted for life. That may be aggravating circumstances. But if he is acquitted in the criminal appeal 19, then that aggravating circumstances may not applicable in death sentence, my lord. So what is I am preferring, my lord, let the 19 may be heard first, then we'll come to the death sentence, my lord. And there's a very peculiar circumstances, also very interesting, some of the aspect connected. Is convicted, the life sentence has been given on the basis of the confessional statement of him recorded in the other case, where the life sentence has been given.
So that cannot be allowed.
That is the
Can it be
question.
allowed?
So that's the issue, is very interesting, my lord.
It can be allowed. I don't know.
I'll place one, whether the section 9 can be applied of the Evidence Act. That's an issue. Because that whole conviction is based on the 164 statement, the confessional statement recorded in the
19.
other case, 19. 18 there is no confessional statement. But the learned trial court has relied on the confessional statement recorded in item number 19.
And he was confronted with it?
No, because it was a confessional statement.
No, was it exhibited in the?
Yes, it is exhibited. That has been exhibited. The learned magistrate also been examined, who has recorded both the confessional statement and which has been exhibited in this death reference also. So whether section 9 we can apply here, and if the confessional statement can be based for both the cases, then in one case.
And in the confessional statement, he admitted to killing both the ladies.
Yes. In the same, more or less same transaction. First day he has killed one lady in the railway compartment. Then second day again the similar nature, he has again killed another lady in the railway compartment. But another interesting fact, when he was brought for the confessional statement in this particular case where the death reference has been granted, he has denied to give confession.
So in 18 he denied, but 19 he gave.
In 19 he has admitted. But the chain is the same. He has denied, whole facts has been narrated, 18, 19 is the similar, same, out of the same cause of action or narration. But that's why the learned trial court, while convicting him for death sentence, he has relied the earlier confessional statement. But in the earlier case, on the same confessional statement, he has given a
So
life sentence.
what does the law say?
Law says, my lord, only the section 9 is the only way out to, for my understanding, the court can look into by way of section 9 of Evidence Act. Evidence Act. Otherwise, there is no such procedure. The explanation C Lordship can look into also.
There is a paper book. How has the learned trial court considered this question?
That's the only relevant point. In the judgment. Page 229, Lordship. Para 59.
Which paper book?
Minor paper book. Paper book, part 1, my lord. Death sentence 4/19. Item 17, my lord.
Oh, item 17. There is a bit of- Twenty-nine. Yes,
Yes, my lord, the paragraph
229, no?
229, para 59. On going through the confessional
Just a minute,
statement
just a minute.
by the exhibit 27.
Yes.
On going through the confessional statement from by the exhibit 27, it appears that through the said confession is recorded in connection with the Moriani GRPS case number 14 of 2018, for which a separate trial was faced by the accused Vikas Das along with the accused Bipin Pandey before the learned session judge Tinsukia in sessions case number 113T of 2018. The said statement being previous statement of the accused because that it can be used in this case also as a relevant evidence to corroborate the other facts. From the contents of exhibit 27, it appears that the accused Vikas Das was admitted on 10/7/18 after boarding the victim RK at the Sibsagar railway station. He, along with the Bipin Pandey, tied.
So this evidence,
Yes.
this confession statement
Yes,
was recorded in the other case.
other case.
It was exhibited in the other case.
Yes,
Was it exhibited in this case?
this case also. And Lordship also kindly see page 76. Page 76, my lord. This is the magistrate before whom he has recorded the confession, my lord. Lordship, kindly see the cross part also. This is the sessions case number, my lord, 130/18. So magistrate was examined in both the cases. Now in the cross part, page 78, Lordship kindly, fourth paragraph. This is important, my lord. I am the Eleka magistrate of Moriani GRP. Accused Vikas Das was sent for police custody for 5 days from 26/7/18 to 31/7/18. On production of 31/7/18, IO has made a prayer before the CGM Jorhat to record, and record was sent to me on that day. I have the knowledge that the accused Vikas Das declined to make any confession before SDGM Najira in Simologuri GRPS case number 6/18. That is the date reference, 6/18. However, on 31/7/18, accused made his willingness to confess his guilt before me. So one case he has declined to make the confession, and the other case he has accepted. Very peculiar circumstances.
But then can we look beyond this? We cannot, I think.
So in the other case, on the basis of his confession, he has given a life sentence, same confession. And believing that the same confession here, he has given the death sentence. And in both the confession, he has also made statement against the co-accused. But he was acquitted from the charge. So that's the issue now. So
How long will you take?
What I prefer, my learned friend starts the other appeal where he has been granted life, that will be better. So that in the death sentence, if he's convicted, his conviction is upheld, then it will be an aggravating circumstances in this case. That means he is committed to murder in the same transaction.
We have fixed that other matter at
Yes.
2. So I doubt whether you'll be able to finish.
No, it will be difficult because both the cases we need to
Yes,
decide together.
we'll have to hear it one after the other,
Yes,
probably.
yes.
And then pass judgments also one after the other. We
Both
cannot
are
pass judgment in one and then pass judgment.
both are interconnected.
Yeah. It'll take time.
Because in the 30 witnesses in that case,
Oh my.
and we have 44 witnesses.
Oh. and we have got one matter at 2.
Yes. So can it be on Monday?
No, we've fixed too many matters. Mr. Akuman. We're fixed. We're already your POXO is also there and then some other is also there. I think,
POSCO will not take much
I
time.
know, but you see, what it has been decided that from the hearing list, every day some matters are being
Adjourned.
put into the part 1 list.
Oh.
So that is how we're exhausting otherwise they don't come for hearing.
Oh.
So that is the problem.
And the death sentence, the preference has to be given priority, my lord.
Anyway, but it'll take too long. That's the problem.
That's the problem.
It'll
If
take
a
too
death
long.
sentence, it will take some time, my lord.
Yes, this is the end of the month, just before the vacation. I don't know whether you'll be able to complete in one day. I doubt. Maybe 2 days required, 2-3 days. After vacation, I think. Because every day. Let us fix it after the vacation. Right. Who is for the, you're for the state.
Actually, that reference has been prepared by my learned friend S. Jahan.
And John is not.
She is
not
on
available.
it. And we have to start with that reference first, That is the normal.
Normal procedure.
So if that sentence is not confirmed, then only question of appeal will come. If the death sentence. is
No,
confirmed by your lordship,
that is all
That-
right, but
that
then
will be on merit.
what they are saying is that the death sentence has been given due to him being given the life sentence in another case.
Exactly.
Because of the aggravating circumstance.
Yes. Now, if the other case, we do not agree with the learned trial court decision, then it is going to have a bearing in the death sentence case. So in that view of the matter, we'll have to hear the other case first. Maybe not make a judgment, but then hear the other case again. And then make 2 simultaneous judgments, one after the other. That will take some time.
In that reference case, first your lordship will strike out the balance, mitigating circumstances, aggravating circumstances. All these matters will come later on, So
Anyway, right, on the prayer of the parties. This is the matter after the vacation.
Well, can it be a fixed date, my lord? It will be convenient for me.
No, this is a 2019 matter. Okay, when do you want? July. Huh?
No.
We have put that.
On 18, my lord, 18th of July.
No, not immediately. We have put those NIA cases, number of them. That is Manipur, concerning Manipur. We have put those.
On 25, my lord.
27. On the third parties is the matter of the.
Oblige.
27 July. 27 July.
Is it your case or this is Jahan's case? This is Bibuya. Or you're the counsel?
I can assist your lordship from the report. Originally, I have not done.
Huh?
I can assist your lordship from the report. Provided it is
I'm
finished
not,
by 1 o'clock.
that is not the question. Are you the PP in this case or it has been assigned to some other?
No, I have to appear, because we can miss. as the
You have
is not
prepared.
there, I have to appear today.
You have to. He's not prepared. Okay, so you have to appear because other PP and other PPs are not there, is it?
Yes.
So that means none of you all prepare your matters. So whoever's there on that particular day will take up the matter. You all don't need preparation, that means, is it?
Today, I am suddenly, interested in this one.
Huh?
Today, suddenly, I am, because, as Zahan has informed, EP, Mr. Mahan Kukuan, that she is unaware. And that is why I am absent.
So you are here. So you are ready. So even if we take up the matter, you don't need preparation. You are ready.
No, we have to, I have to assist the record from the records. I have to assist the losses from the records.
So that
Yes,
means you don't, okay. So so you don't need to read at home and all. You are ready, like this straight away.
Today I could not do that.
Should I start?
One thing,
I'm slightly confused.
I know.
Because what the additional PP seems to be saying is that they don't need to read in advance. Whoever is present on that day as a PP will just carry on.
No. I mean, I did not mean that. What I'm meaning is that if I have to appear in this case today, instantly I have to go through the records because earlier I did not appear, perhaps I did not.
That is what I'm saying.
Before the division bench.
That's what I'm saying.
Today it has been made forget management only. That is the problem. Due to illness of.
That is why. So you have not read the file.
I have not.
So how are you going to assist? Madam, you are the PP out here. As the last court order says, Ms. B. Buyan, learned additional PP represents the state.
I don't have the record. Our office today provided me two files.
Ah.
One got a job, one I prepared which need to deal because I had to go to another court matter. Which should be taken up at 2 o'clock. That I have ready. And one got a job.
So, but he's ready. Anyway, I don't think he's ready. It will not be fair. Have you read the file, Mr. Counsel? No.
Right, I think, my lord, if I start with the evidence, my learned friend will get the time. It's a case where, my lord, the conviction, the sole ground of giving conviction is a confessional statement, my lord, which is retracted in 330.
Retracted.
Retracted.
Anyway, let Ms. S. Jahan come. She's the counsel, she's the PP. We won't have time. 2 o'clock, we've already fixed another matter.
My lord.
No time within this, right? As Ms. S. Jahan, the additional PP who has taken up this matter is reportedly unwell. Matter is adjourned till after the vacation.
My lord, can it be in the first week of August or second week of August? Because
Okay,
I
leave
have
the
some-
matter in the
second week of August.
Second week of August.
All right.
Similar point, what Supreme Court has got to say, kindly give the judgment of Shambhu Das. I'm saying Shambhu Das, 2010 10 SCC 374. Here I'd like to point out para 26 onwards. Similar type of situation was dealt with it by the Honorable Supreme Court, my lord. If your lordship will see what is investigation, my lord, that H.N. Rizban case also. is
That
there.
earlier 2010 criminal law journal, that is,
That is from Guwahati, my lord.
where is that copy? We have got 2 copies.
210 criminal law journal, 781, my lord.
Yes, the 2010, para
Yes,
26.
26, my lord. What is investigation that has been defined under the code as 2H, my lord? Section 2A CRPC defines investigation as including all the proceeding under this act for the collection of evidence collected by.
I think that Rajkumar's case gives that.
Yes, ma'am. H and Rizban.
Yes.
Yes, ma'am. So section 157 CRPC states that from the information received or otherwise the officer in charge of a police station. I'll go directly, my lord, in the middle. In order to bring such proceeding within the ambit of investigation, it is not necessary that a formal registration of a case should have been made before proceeding to the spot. It is enough that he has some information to afford him reason, even to suspect the commission of a cognizable offense. Any steps taken by him pursuant to the information towards detention, etc., of the said offense would be part of the investigation under the code. So here, my lord, many things were done by the GD entry, my lord. Then the relevant para 31, my lord.
But
30 and
then,
31.
this does not mean that FIR cannot be filed.
No, FIR can be filed subsequently, but that FIR will not be treated as an FIR. That FIR will be a 161 statement, subsequent statement, my lord.
It does not say here. In this case, it does not say that.
Or maybe.
In this case, it does not say that. Only the division bench judgment of our court
Mm.
may be construed in that line, but not this case.
No, that's why I'm pointing out fairly, my lord, that there is a counter case also. My duty to point out fairly, which I'm doing it, my lord. There is a proposition also there, my lord. So let us go to 30, my lord. The principle, because if I know there is a judgment contrary to that, my lord, it's my duty to point. it
Correct,
out.
sir.
The principle now well settled is that when information regarding a cognizable offense is furnished to the police, that information will be regarded as the FIR. And all inquiries held by the police subsequent thereto would be treated as investigation, even though the formal registration of FIR takes place later. Now, what happens later FIR? That is
Okay.
the thing. Assuming in that some report was made on telephone and that was the real first information report. This by itself would not affect the appreciation of evidence made by the learned sessioner and the conclusion of facts drawn by him. The FIR under section 154 CRPC is not a substantive piece of evidence. The only use is to contradict or corroborate the maker thereof. Therefore, we see no merit in the submission made by the learned counsel for the appellant. So this is one proposition coming from Supreme Court, mind. That our High Court went a step ahead and has given graphic details of it. But here the Lordship says, the Honorable Supreme Court's Lordship says that the investigation may go on. But that will be treated subsequently as an FIR, my lord, is a later part, my lord. Formal registration, my lord. Then that will be not a substantive piece of evidence, my lord. That is why I'm saying at the outset that just because there is the second subsequent FIR, my lord, just because for that the case will not fail. But that appreciation is necessary, my lord. That's why I pointed it out, my lord. So these are the two legal propositions coming out from the courts, my lord. So now we'll deal with, my lord, regarding the merit of the case, my lord.
How, now suppose
Fine.
that exhibit 5 is treated as first FIR, how it helps your case?
It helps my case because the story narrated out there was completely different, my lord. The person who has informed my lord that there was a fight between two group of people regarding some landed property dispute.
No, it was only an information.
Yes, my lord, disclosing a cognizable offense. I can read for your lordship's benefits, my lord. What was the contents of that exhibit 5, my lord? One Fozlul Haq of Sahapur informs of a phone that following argument between the members of two families. It is the case, my lord. with regard to certain land in dispute, they have stated in the FIR that they have entered into a fight being armed with now. That is, both the parties were fighting. It is not that we have killed somebody, my lord.
No, what my. You make me clear, make us clear
Sure,
that,
I'll try my best. my lord.
that it only relates to how investigation started. What was the actual fact would be revealed only after investigation.
Hmm.
To what extent that exhibit 5 is relevant.
Exhibit 5 says a story. FIR also says a story. Now, this is at the first point of time.
Yes,
That FIR was lodged after 10 hours of the occurrence. Morning 8 o'clock occurrence. This is 8 o'clock entry. And the FIR takes bond at 6 p.m. That is after FIR. Here on the spot, the FIR information exists that day. So every case has got its own factual foundation, my lord. So this fact was the actual fact what has happened in the occurrence place. my lord. They have projected one side of the story. That is my contention, my lord, in the FIR. They have not come out with the truthful. one.
Was this Fazal Haq, was he made a witness?
No.
So you are trying to say
Yes.
at the end of the day that he was a material witness who was not brought. That is what you're trying to say.
One aspect. That investigation is a very vital piece of information. That would have shown much more better light. Because here we are getting the interested witnesses person who is hell bent upon to see that I am convicted at by hook or crook. But what happened actually? That part is missing.
No, but at the end of the day, okay, there was a fight between two persons. Or two families, maybe, groups of people. But there is a dead body. Now, whatever may have been the reason for the fight, the issue is who had killed that person, that dead person.
My lord, your lordship is absolutely right. But with that, there will come a rap, my lord. The rap is that, my lord, that whether I exercise my right of privacy, whether they were the aggressor, all these things will come up, my lord, from this information, my lord.
No,
not
that will be from the investigation.
Yes.
What,
That faulty
how does
investigation-
this information
That
at 116?
That faulty investigation has been done. That will be my trust to show your lordship. So much of improvisation, so much first time before the court deposition was stated, my lord. Because this investigation is on one track. Because here, if your lordship will see, he says that two persons were lying injured on the field. So now where did the other person vanish? It is from our side. This person was about to die. Unfortunately, their person died. So
And your person became well.
my lord, fortunately. But unfortunately for the case, he is an accused. So actually the things happen this way, my lord, in the during in the same state. There is no counter FIR. As I'm told, my lord, there are injuries on our part also. They were in the hospital. It has come
But there is no counter FIR.
Yes,
Then
that because at that time save your soul. That's why it was moving, my lord. So that is what I'm trying to project from here, my lord. But whatever I say, my lord, ultimately, what is the substantive evidence that in the evidence, my lord, in the court, my lord? Both examination in chief as well as cross examination. What material comes up that your lordship will appreciate. Vis-a-vis the other materials available, other law point materials available. So that's why I'll like to take your lordship to the charge first for what I am charged by. Because here only one single step injury.
no, whether trial court relied upon that FIR, second FIR as a corroborative piece of evidence.
No, I don't.
Then
find.
how it is material,
That,
whether the FIR is.
that's why the trial judge is wrong, my lord. Trial judge ought to have taken that as an FIR and start the judgment, my lord. That was never taken into consideration.
according to you, trial judge should have taken the GD entry as a first
That's
FIR.
Absolutely. Absolutely.
Thereby meaning to say that the maker of that FIR should have been examined.
One aspect. And the other aspect, the story as narrated in the GD entry. Right? That lends supports to my case and lends credence to the whole factual matrix of the case. That separation of the genesis of the prosecution case, as we say in legal terminology, that the prosecution has not come with clean hand. They have tried to suppress the genesis of the prosecution case. So that is materially affecting the case matter. So if we go through the evidence, your lordship, things will come up more clear.
Yes,
My lord, the charges are at page 7, my lord. I'm facing the trial for the following charges. All the name accused, 7 accused are before your lordship's name. Firstly, that you on or about 16/2/2012 at 8 AM on the road of village Saharanpur, Sorbuk PS, were a member of an unlawful assembly and in prosecution of the common object of such assembly to commit murder, thereby committed the offense under section 147. Later on, probably 149 was inserted, if your lordship will see. But there is no initial, but we take it the charge was framed. But a session judge would have been more cautious for that matter. 147/149 of the IPC and within my cognizance. Then you are on the same day at the time place where a member of unlawful assembly were at the time armed with deadly weapons such as dagger, dao and other sharp cutting weapon to cause the death of Kadir and did in prosecuting the common object of the assembly commit the offense of rioting with the said weapons and thereby committed an offense punishable under 148, 149 of the IPC and within my cognizance. That you honor about the same day at the time and place you were a member of an unlawful assembly in prosecution of common object of all have committed the murder by causing the death of Kadir Ali and thereby committed an offense punishable under 302/149 of the IPC and within my cognizance. Then fourthly, you on the same day place you were member of an unlawful assembly in prosecution of the common object of all voluntarily caused hurt to Korimun Nessa, that is PW1, the informant. And I am acquitted from this charge by means of blood weapon and thereby committed an offense punishable under section 323, 149 IPC and within my cognizance. Fifthly, that you on the same day, time and place, you were a member of an unlawful assembly in prosecution of common object of all voluntarily caused a hurt to Saidul Islam, he is PW4, by means of dagger, dao, palla, which is an instrument of stabbing, and thereby committed an offense under section 324.
Saidul Islam is PW4
Yes, madam.
and this Koriman Nessa is
1, madam. Right? 1 and 4, madam. PW. Saidul is PW4, Korimun Nessa is PW1. So charges punishable under 147, 148, 302, 323, 324, 149 of IPC are framed against the accused and the same are read over and explained to the accused to which they pleaded not guilty and claimed to be tried. So these are the charges which I have to answer by. So I have been acquitted from the 2 charges regarding the assault part. Now on the same evidence, set of evidence, we have been convicted under 302. Whether that aspect can be segregated, my lord. Because the occurrence is one, the story is one, the evidence is one, the narration is one. Now, how do you segregate that evidence?
no, so you were guilty of all, maybe they thought that this may not be necessary.
Oh, well, we'll come when.
And
But this is actually the, because if you can.
because under 302, these can come under that also.
But for that, if the evidence are so intricately connected, my lord, that you cannot separate the grain from the chaff, then my lord, it has to be read as a whole. But if that separation can be made, then my lord, your lordship, that will be in consonance with the law. If it is so intricately connected, that one chain of events, so you cannot cut the chain, my lord. You have to take the evidence as a whole appearing before the court, my lord.
But then, if the chain of events
Yes.
is intricately connected and it's been proved, it doesn't mean that he has to, that the court cannot convict you with the ultimate, I mean, the most severe punishment and leave aside the lesser
No,
punishment.
my contention is that their evidence becomes doubtful, my lord. If they say that we have received injury, if the investigation found I have received injury on the same event, on the same occurrence, then how can that be that she was herself present? Because she has stated that I was present and I was assaulted in the spot. But nothing comes out in during the evidence stage, my lord. Why I've been acquitted on the same set of evidence, my
Anyway, let us see.
lord. Yes, madam. So PW1 appearing at page 10, my lord.
Yes,
My lord, page 10 PW1, Masamat Kariman Nessa, that is the informant. I am the informant of this case. I have instituted this case against accused Shahjahan, Fakir, Tohibur Rahman, Abdul Haq, Abbas Ali, Abdul Ghaffar Malik, and Abdul Hai Fakir present in the court today. Around 8 to 8:30 AM on 16/12, my husband Kadir Ali went out to the road in order to call people of the Mel meeting. Now I'll show your lordship. If we go to page 5 of the FIR, there the version is different. Here it says, if I understand this translated line, the husband went out to the road in order to call people to the meeting, my lord. Now let us come to page 5. The line goes like this, that around 8 AM, second para, my lord, of page 5, that around 8 AM on 16/2, when the informant husband was going to attend the mail.
so how does it make a difference? He was going to attend and he was
different-
calling people also. How
No,
does
my
it
lord.
matter?
Difference is that he is going to attend the mail, means everything is ready, he was going there, my lord.
Hmm.
And here husband was going to call people to
No, doesn't know
to
that
make a
how
gathering,
is
my lord.
that? That's such a small.
The
No, no.
discrepancies, my lord.
No, no. Sometimes you go to the carnival or to the fair or to some shopping, you call your friend also along. How does it matter?
No, here the evidence is that in order to call people to the mail. So people have not assembled. Here the FIR says to attend the mail, that is the mail meeting is
How does
ready.
it matter?
Meeting
It
is
very
ready, my lord.
minor. There's nothing here.
Here they were going to call the people.
They were going to call the people doesn't mean that no one was there.
No.
It could also mean
One
that
thing is that peoples are already-
number of people are already there.
Peoples are already assembled. And here you are going to bring the people.
No, no, no. Nothing like that. Nothing like that.
Well, my
You see, we have also had many programs made. And then we find that the hall is quarter full, only quarter is full. So then we start calling up this person, that person, we tell our friends and our junior officers, go and call, why haven't they arrived? That doesn't mean that no one is in the hall. It means that there are some people, but maybe not enough. That is neither here nor
But here it was a private mail, my lord.
whatever it is.
Anyway,
What mail is a meeting, we don't know how many are supposed to attend, who are to attend. That is neither here nor there.
I followed my husband. When my husband reached near the pond, near our house, accused Shahjahan, Abbas, Abdul Ghaffur, Khaled, Abdul Haq, Toibur Ali, Abdul Hai, armed with dagger, douse, spear, lathi, came running and accused Malik and Abdul Haq directed accused Shahjahan to kill my husband. So this two person has extorted,
Exhorted, accused.
yes, Shahjahan. So there is no charge to death, man. Abatement. That I abated Shahjahan to kill me. And neither in the FIR that is coming also.
Maybe this lady has heard it.
My lord, in a criminal case, there will be no maybe, my lord. It should be beyond all reasonable doubt, my.
Came running and accused Malik and directed. So it appears that she has heard it. That's what she's saying basically. She has heard them saying.
Heard him saying that Malik abated or
Yes,
extorted.
exhorted so Shah Jahan to kill her husband.
Then accused Shah Jahan stabbed my husband Kader in his belly.
With dagger in his hand.
But PM says, of course, your lordship will again say there's the distance. PM says is it on the chest. And here it is in the belly. With the dagger in his hand. My husband sustained injury and was bleeding. PM report will say it is on
So
the
out
chest.
here, okay,
The one injury. madam.
so out here,
Yeah, ma'am.
as per this, it appears that only Malik, Abdul Haq and Shah Jahan are involved.
To an extent.
So yes,
Now others will come.
then yes, you have got to make it smaller and smaller.
Filtration. my
Yes,
friend.
filtration process.
Yeah.
So the first filtration
First
it appears.
filtration, 3%.
appears subject to what the other
Yeah,
side
yeah,
says.
what they will say.
It appears from this PW1 statement that though all 7 accused were there, only Malik and Abdul Haq had exhorted Shah Jahan to kill the husband, and accordingly Shah Jahan stabbed the husband. So only 3. So whether 149, 30 to 149 could have been, attracted by all the accused. That is one. Then, yeah,
My husband sustained injury and was bleeding. He fell down on the ground. That is exhibit 5 pilot. When I ran towards my husband to hold him, accused Abbas and Gofur came. Accused Abbas had on my right hand with a dao, and Abdul Gofur assaulted me on various parts of my body with lathis. So in that event, my lord, this medical must have been examined, my lord. These medical reports are not placed on the records, my lord. If she has received so much of injury, she would have been at least medically treated. But not a single medical document has been produced before the court, my lord, that she was actually assaulted, my lord. So
no
these are
medical
all,
document.
yes, my lord. No medical document. And that is why, my lord, this relates to the 4th charge, 324, my lord. 4th charge, as our lordship has pointed out,
Yes.
that is 323, my lord. And 324. The other accused person,
Just a
namely,
minute, just a minute. 323.
that is at page 8, my lord.
So. Yes, 323 only.
Hmm.
324 is with regard to some other person.
That PW4, my lord.
Yes.
The other accused person, namely Malik, Abdul Haq, Abdul Gofur, and Abdul Hai, has also tried to kill me. Just omnibus statement. I raised halla, whereupon people from the neighborhood came, put my husband and me into a vehicle and took us to Sorbog Hospital. Therefrom, we were taken to Borpeta Road Hospital. Since no treatment could be provided there, we were taken to Lower Assam Hospital, Bongaigaon. There, I was told that my husband Kader was dead. I underwent treatment there. So this medical report could have been easily procured, my lord. The postmortem examination of my husband's dead body was done in the hospital. My husband's dead body was brought home. So your lordship will kindly take note of this. That the dead body was directly brought to the home, my lord. But if we looked into the evidence of PW9 and at page 41, it will be seen. If I can take your lordship to page 41, it was taken to the police station, my lord. If your lordship will kindly trouble yourself at page 41, my lord. Kindly page 41, PW9, around 3:30 PM one day, on hearing that Kader's dead body have been brought to Sorbuk police station, I went to see it. I saw the dead body of Kader in Sorbuk police station. It is coming in examination in chief. So this lady who was there, my lord, along with her husband, my lord, and who was also under treatment, my lord, says that no, my husband's dead body was brought to home.
maybe the home was after passing the police station.
But this should come in evidence, my lord. We can't.
No, but
infer,
then,
my lord.
where is it in opposite directions? The home and the police station. or
The
is it the
sketch
same-
map doesn't show as such, my lord. I checked from the sketch map, my lord, but I could not find as such, my lord.
So what are you trying to say? That she's a.
This
not-
sketch map is at page 118, my lord. Chapur Village Road, police station is 5 kilometers away. Page 118, my lord.
No, but how does this, how do we know that the police station was not on the way home?
Maybe that is the duty of the prosecution to establish, not to disprove by the accused person, my lord. I have to prove my case by preponderance of probability, my lord. Prosecution has to prove beyond all reasonable doubt. So it was their duty to put it, my lord, that yes, on this point, they could have re-examined her, my lord. Then the evidence go like this, my lord. I was brought home that day. That day itself, I lodged an Azahar with Sorbuk police station. I put my thumb impression in the Azahar. I got the Azahar written by a person. Police examined me. So the FIR was also not exhibited through her. Probably she was giving her LTI man. But at least that should have been brought into record, I think, because she was the informant of the case. After the occurrence, when I raised Halla, my brother-in-law's husband, Sofiul Islam, that is PW4, reached there, and then accused Abdul Hai stabbed him. That is, stabbed him means PW4. That is the fifth child. On his belly with a knife. It's a serious injury, my lord. Maybe 307 would have
No
also.
medical document.
No medical document, nothing. This is the fifth charge which I am acquitted of. He sustained bleeding injury and was taken to Sorbuk Hospital. Since no treatment was provided to him, there he was taken to Borpata Medical Hospital where he underwent treatment. From there he was brought home. My husband was buried during the night hours on the same day. The accused person left the weapons which they assaulted and stabbed us at the place of occurrence. Bilal Hussain, PW9, that is PW9 Bilal Hussain, brought the weapons by the vehicle in which the maternal uncle Somsul took and brought us back to the police station and over to the OC police station, and actually I handed over the same to her. This Somsul is also not a witness. So this Bilal Hussain PW9, my lord, he doesn't state from where he got it. He just produced some instruments, some weapons. So whether that was, if at all it was used, so it was the duty of the police to send it for FSL, not done. That blood group could have cleansingly lead to the fact that yes, this is the weapon used at the commission of the crime, my lord. That is also not done. And the most important that is not done was that the person who was bleeding out there, my lord, as the GD suggests, that's why I was insisting on the GD, my lord. The art laden with blood, my lord, should have been picked up and sent for the FSL, my lord. That is also not.
But okay, that is with regard to this person PW4 or 5, whatever.
No, also for the deceased also, my lord. He
But
was
for the
grasping
deceased
for
had
death.
died.
My lord.
When the deceased dies,
Yes,
when the deceased, the cause of death was the assault, and that has been seen by eyewitness, is there a requirement for the weapon to be there, to be exhibited?
No, weapon is not required, but that the occurrence took place at the manner suggested by the prosecution is not coming forth, my lord. That where is the actual place that took place, my lord? Because
Actual place of?
actual place of the occurrence, my lord. Because they were going to the mail to a school and that occurrence took place as per exhibit 5 at the paddy field. Your lordship will get it again in the sketch map, my lord. You want to see?
Did you cross-examine the witness on this count that you have not stated the place of occurrence?
My lord, that is one lines coming, my lord. I'll take one by one. Because the chief is of 1.5 page process of
Yes,
3 page.
next.
Cross starts from page 12, my lord. The Ajahar, that is the exhibit, not yet exhibited, was written by a person at Sorbuk police station. The said person works there. 7 persons were named in the Ajahar. In the Ajahar, I mentioned that there were other persons beside the 7 persons present in the dock. So more persons were there. But only 7 has been charge sheeted. I put my thumb impression on the Ajahar after the writer has read its contents over to me. Mail was not held the way I mentioned in the Ajahar. That is what I was trying to impress, my lord. That no mail was being held. So the question of going out for the mail is not believable. Mail was not held the way I have mentioned in the Ajahar. My husband had gone to call people to mail. I stated the scribe that my husband had gone to call the people to the mail. So there are 2 different things, my lord. What I am suggesting, my lord, that if the mail was on, the peoples have assembled, then he is going to attend it. So my contention is that this is narration is completely a cooked up story, my lord. Nothing as such mail, no person has come and said, my lord, that he came to invite us for the mail. So the story of mail being introduced was a subsequent afterthought event, my lord.
No, she has clarified in your
My
cross-examination
lord.
that husband went to call people
Yes.
for mail.
But in the FIR, mail was
She
on.
has also clarified that I told the scribe to write.
Yes, my lord, and it was read over to her and she has accepted it to be correct. So what she says in the FIR, my lord, that mail was going on and he was on the way to the mail. On the contrary, it comes that no, my husband was going to call people to make them assemble so that the mail takes place.
Otherwise, is it a material contradiction?
I think so, my lord, because of the fact, my lord, that something has yet to happen for which they are saying has happened. That mail has not happened. So the occurrence took place not in the mail place. The occurrence took place in a paddy field. They have subsequently developed in their afterthought measure in the FIR. As per GD, it was in a paddy field. And that paddy field, if your lordship will see whether it is traced out in the map, my lord. There is no such paddy field coming up, my lord. Because the police acted on the basis of the FIR. The whole genesis of the prosecution case as per Exhibit 5 has been suppressed.
But paddy field will be contiguous to a road.
But whatever it is given, my lord, we cannot go beyond the record, my lord. The record says, my lord, that the occurrence took place near the pond wherein there was a school, LP school, my lord, wherein the mail was supposed to be held or was going to be held. 3 words situations are there. Mail was supposed to. If your lordship will see Exhibit 7, page 118, the sketch map, my lord. It distinctly shows
Page,
page 118, my lord, Exhibit 7, the sketch map, which denotes where the place the occurrence took place, my lord.
yes,
It was a dry pond with no water of Kader Ali. That's the pond.
107.
118, my lord. 118, my lord.
Yes.
This B and C is the meeting place, my lord, LP school, my lord. And contiguous to that is D, my lord. There's the house of the accused, my lord, Shah Jahan. And E and F is the house of the informant and the deceased, my lord. And exhibit, index G denotes the tea stall of Toibur, that is accused number 5. Who expired?
Who is the one who expired?
Toibur, my lord. Toibur Rahman.
Toibur Ali.
Yes, my lord, but here it is written as Toibur Ali, my lord. Alias Toibur Ali, my lord.
So what is his name?
So here it comes in the paper book as Toibur Ali, my lord, but as an appellant, we have filed it as Toibur Rahman, my lord. Alias Ali, my lord. It is written, my lord. Toibur Rahman, appellant is Toibur Rahman, alias Toibur Ali. At page 139. So I proceed, my lord. Except Shahjahan, no other person assaulted my husband. So one man assaulted, your lordship got it, and it is further corroborated here. I stated to the scribe writer of the Azhar that accused Abbas hacked me on my right hand with a dao, and Abdul Gofur assaulted me on various parts of my body. It is not a fact that the scribe has not written in the Azhar that accused Abdul Hai stepped my brother-in-law, husband's brother, Soidul Islam, in his lower abdomen. So in the FIR, that vital information was also not there. The PW4 was assaulted in his belly. In any case, they are acquitted, my lord. I have 7 sisters and 7 brothers. Accused Shahjahan, Abdullah and Toibur Rahman are my brothers. We have around 13 bighas of ancestral land.
Toibur Rahman
Yes.
is one of the appellants.
Brother, my lord.
He's one of the appellants.
Yes, my lord. He died pending the appeal, my lord.
Shah Jahan is also
Brother, my lord.
Abdul Hai also.
Yes, my lord.
So this witness,
So the brother-in-law was killed, my lord.
these are brothers, not brother-in-law.
No, no, deceased, my lord.
Huh?
Deceased. Deceased happens to be brother-in-law of the accused, my lord. Informants happen to be the sister of the accused.
PW1
Yes,
is the wife of the deceased.
yes,
And Shah Jahan, Abdul Hai and Toibur Rahman, the appellants,
yes,
are the brothers of PW1.
yes. So
this is a
that way,
family-
the deceased becomes the brother-in-law, my lord.
He's a brother-in-law.
That is the family dispute.
So why should she tell a lie?
No, she is not telling a lie because of the ancestral property to grab the ancestral properties, my lord. So that is what I am saying that at the outset, my lord, that there was a land dispute. It was a free fight between 2 groups of people. Who hit whom? That has come up subsequently in the evidence, my lord.
And
That,
very close family fight.
yes, my lord, absolutely,
Because deceased is the sister. Basically, the sister and brother are fighting.
yes. For property. But the facts, my lord, 2 person exalted, 1 person Shahjahan assaulted. So only 1 step injury. That proved to be fatal, my lord. So how much 149 will be affected in those type of situations? Because other person, they say assaulted, so they were left out from that assault part. So by virtue of the aid of section 149, my lord, this other accused person has been roped into in this case and convicted, my lord.
So as per PW1, Malik, Abdul Haq and Shah Jahan, 149 is appears to be
Prima
applicable.
facie, it seems so,
appears
as of now.
as of now.
But so for the other 4 accused person, no role, no act has been attributed. And she herself says at page 12 that except Shahjahan, no other person assaulted my husband. So, 3rd para, my lord. Opening line, except Shahjahan, male after male para, except Shahjahan, no other person assaulted my husband. I stated to the scribe writer of the Azhar that the accused Abbas hacked me on my right hand. So all these injuries are missing, my lord. No medical report, nothing, my lord. Merely narrative, my lord, to build up the case, my lord. Then this, your lordship will see now the genesis of the story of the prosecution case. Why it happened? I have 7 sisters, 7 brothers. Accused Shahjahan, Abdullah, and Toybur are my brothers. We have around 13 bighas of ancestral land. The homestead land of which our house is situated measures more than 3 bighas. I purchased the homestead land from accused Shahjahan and Toybur. Now, if your lordship will kindly turn to page 5, my lord, your lordship will see for how she acquired the land.
Page?
Page 5, FIR. FIR story is what, my lord? The informant has the honor to state that 11 years ago, the informant purchased a plot of land 1 bigha 10 acres situated towards the north of the house of her husband from the father of the accused 1, 2, and 3. Not from her father, she said, but from the father of 1, 2, and 3. 1, 2, and 3 are these 3 persons, my lord. In FIR, she says it was purchased from father.
So,
And here she states,
so what you're saying is that there is contradiction
yes, my lord. Going to
with
the,
the
page-
FIR, which has to be read as a substantive statement.
absolutely.
Now,
And
Uh,
going to the root of the case.
contradict to contradict that witness, to contradict PW1 with regard to her evidence, she will have to be confronted with the statement. That is the FIR. Was she confronted in the cross-examination?
I don't think, my lord.
Then how does that?
My lord, with all respect, I'll submit, my lord, it's not necessary because the FIR is in existence. And the
No, no,
evidence is- no,
the
vis-a-vis, my
the
lord.
Supreme Court has said that it is required.
My lord.
I'll give you the
But
judgment.
since the FIR is in existence, had the FIR not been.
Your case is this. The GD entry has to be read as the FIR. Because the investigation started on the basis of the GD entry. The FIR that was recorded at, submitted at 6 p.m. has to be read as a substantive statement and not as a FIR due to the GD entry, which apparently, according to you, showed a cognizable offense had taken place. Now, you are trying to say that the evidence of PW1 is not reliable due to the fact that there is a contradiction with the substantive statement as provided in the FIR. Now, for that, for contradicting a witness, subject to what you say, what I think is correct because of a Supreme Court judgment is that that statement made to the police, which is a statement under 161, has to be put to the said witness and confronted with that statement, and that has to be reflected in the evidence. Now, that is not here. So how can you now?
I respond to that.
Yes,
I'll try to satisfy your lordship. That is the situation wherein 161 has been recorded.
Correct.
And on the basis of it.
Correct.
Here a documents exist.
Correct.
Which is to be read, can be read, my lord. So if we take the documents and the substantive evidence given in the court is conflicting, your lordship will be within the ambit to look into it, my lord. Because the documents.
But
is
no, but then this,
No.
this FIR, the statements made in a FIR, what can it be, what can it be, supposing you don't consider it as an FIR? So what would it be considered as to be recorded against which provision of law? Under
161 statement.
So 161.
Yeah.
So 161 is against statement to the police, same thing.
Yeah, absolutely. This is also a statement to be taken as 161 equivalent, no doubt of it. But once the document exists, my lord, we can look into it
You
because,
can look into it,
Your
but you have to
lordship-
confront the thing.
because your lordships and the court say man may lie, but the documents will not lie.
But
So
then,
that document is in existence.
correct.
What is here
But then to
incorporated.
discredit,
We can look into it.
but it cannot be used
No,
for adjudicating an issue unless or deciding the reliability of a witness unless the witness is confronted with the said document or the statements or part of that document.
But I'll reiterate my submission and say, my lord, once there is a document, that document will override the oral statement. because the document said this
Will
way.
override the oral statement made under oath.
Oh,
according to-
definitely, madam, definitely. No, I'll give
No,
an example, if your lordship,
One query,
yeah, my, please.
had that FIR been shown to the PW1 for confronting or
Confront her.
contradicting her, she could have given some explanation,
Maybe,
but without doing so,
well, actually, while in the cross examination, the thing stands like this. If we give a chance to the prosecution witnesses, so the explanation will always be there. So it is the duty of the prosecution to to prove a case beyond all reasonable doubt. My duty is only to throw some doubt, that is preponderance of probability. It is she coming up two version. So which version your lordship will pick up? In evidence she is deposing, my lord, with all respect, that I have purchased it from my brother. In the FIR, in a written manner, he has
no.
stated,
as for using a previous statement for for the purpose of contradicting the witness which you are submitting, that previous statement is to be brought to the notice of the witness. In this case, the previous statement is the FIR, according to you,
no, correct.
that has to be brought to the notice of, without bringing it to the notice, whether same can be used for the purpose of disbelieving.
Yes, my lord, because two versions are emerging now. Which one your lordship will take? On records, it is written.
We will have to take the one, I think, under which has been made under oath.
Yes, absolutely. That is what I'm saying. So
Under-
I am trying to show now if your lordship wants to see the appreciation of evidence. If we go to section 172, it can be taken into aid to look into the case diary, whether this contradiction exists or not. Even if there is a failure on the part of the counsel of the defense, my lord. That is also taken.
But they have to be confronted with the said issue.
Suppose it is not done, then what
Then-
happens,
then-
my lord? Then 172, my lord, if I'm not wrong. It can be taken into aid, my lord, to diary proceeding. Every police officer making an investigation under this chapter shall by day entry the proceeding in the investigation in the diary forthcoming with the information received him. The time at which he began and closed the place or where the statement was ascertained to the investigation. The diary referred any criminal court may send the police diaries of a case under inquiry or trial in such court and may use such diary not as evidence in the case, but to aid it into such inquiry or trial. So by this, your lordship can look into it. I'll place judgments on. That diary cannot be used.
Anyway, okay, then
Okay.
we'll, it's good we're dissecting each and every issue.
No, my lord, we are also learning, my
No,
lord.
no,
So nicely
you see, we are trying to understand.
My lord, absolutely.
You know the case.
No, no.
We are trying to understand
yes.
your view.
Right.
Yes,
That's correct.
okay.
So there is a material contradiction, my lord. In the FIR, she says she has purchased it from the father of the accused 1, 2, 3. And here she says that I have purchased a homestead land from accused Shahjahan and Taibur. So her motive is completely different to grab the ancestral land, my lord. We have dispute regarding the homestead land with accused Shahjahan, Taibur and Abdullah. That is the brothers. Since prior to the incident of my husband had gone to call people for mail with regard to the matter dispute, I purchased the land through a registered deed. I handed over that deed to the police. I have a copy of the deed, but this deed was never produced in the court during the trial. There is a public road to the west of my house. There are shops on both the sides of the road. Except my brothers, rest of the accused brothers have, probably it should be no typographical, my lord. Shall I read my? Except my brother, the rest of the accused person have no enmity with us with regard to the homestead land. That no has been typed as probably N, my lord. So these are the three brothers. The house of the accused Malik is about 1 kilometer away from that of mine, and Gofur's House is also situated at the same distance. The house of accused Abbas is about 2 kilometers away from that of mine. Abdul Haq house is adjacent to that time mine. The accused person have their respective own houses. The husband has called for a mail on the day, my husband has called for a mail on the day of occurrence itself. My house and that of the accused sergeant's house are situated adjacently. The house of accused Abdul Hai and Toibur Rahman are situated at other places. There is a small lane leading to the public road from my house. There is a school in between my house and the road. The mail was supposed to be held in the said school. I also followed my husband to call the people to attend the mail meeting. My husband was clad in a shirt, a pair of trousers and a vest, and I was clad in a sari. My husband was clad in a cream colored shirt and white vest. The shirt and vest of my husband got pierced. The clothes were stained with blood. There were blood at the place of occurrence too. That is what I'm emphasizing, my lord. The clothes were never sent for epistle. Suppose it is not required, as if your lordship will say. But what about the blood fallen on the field, my lord? Police took the shirt of my husband away. They did not seize my clothes. Police collected blood-stained art from the place of the occurrence and took the same away in a plastic packet. Where is the FSL report? It has not been exhibited. Neither it has been brought on record. If that exercise was at all carried on. The weapons brought in the vehicle in which we carried were also stained with blood. So the weapons used, it is said it is blood stained. So then it was the duty of the prosecution and the police also to send it to the FSL for obtaining the report. Nothing as such was done. From the place of the occurrence, Bilal, Soidul, Somsul and my husband and I came to the hospital at the PS by a vehicle. First Bilal, that is PW9, handed over the weapons to the police station. I was present there then. So she doesn't file the FIR because the story goes like this, my lord. From the occurrence, they took her to the Sorbuk first, then to Borpeta, and from Borpeta to Bongaigaon. Thereafter, they come according to PW1 direct home and then cremation. But here now again, it comes that we goes to the police station in the cross. And then she doesn't file the FIR. Neither the police ask to file the FIR. It is after discussion and everything, my lord, this FIR took the shape by incorporating the names of the accused persons. I lost the FIR at 7 p.m. though it is registered at 6 p.m. after coming back from hospital. At that time of handing over the weapons, police questioned me. I stated verbally and police wrote the same down. Thereafter, police took us to the hospital. Police questioned us in connection with the incident before lodging of the FIR and wrote our statement done. So this statement of hers under 161 was recorded as part their GD entry, not as part this FIR. She is speaking in clarity, sir. Thereafter, police took us to the hospital. Police questioned us in connection with the incident before lodging of the FIR as a and wrote our statement down. The doctor sees the injuries of my husband. I became unconscious after I was put in the vehicle. So this is the starting point. Till then, the FIR lodged by her was not in existence. This is police investigation already comments as part of GD entry, which I am trying to impress upon your lordship that police came out, started the investigation. I do not know if Shahjahan and Abdul Hai sustained injury in the incident and underwent treatment. So these are the accused, my lord. The name of Abdul Hai's wife is Zalekha Begum. I do not know if Zalekha Begum lodged any case against me and members of my family in connection with the incident. Of course, that will be our duty to do, but we have not discharged our duty to that extent, my lord.
Okay, just one thing.
My lord.
This Abdul Hai,
Yes.
is he Abdul Haq? What is this?
Abdul Hai is the accused, my lord. Let us check.
No, because you come to page 10, there is one Abdul Haq and there is one Abdul Hai.
No,
Okay.
here in the appeal memo, it is Abdul Hai Fakir.
Abdul Hai and Abdul Haq are different.
Different person.
Different.
So there are two.
His number 7 is the Abdul Haq brother. His father's name is Basir Ahmed.
Okay.
His Basir Khan. And where is Abdul Hai is brother of accused number 1 and 2.
Abdul Haq is son of late Basir Akan.
Yes. Basir Khan.
2 minutes. We'll just rise up for 2 minutes.
My lord, sure.
Three question answer to see answer. You are answering the আমি যদি 1 নম্বর দিয়ে শেষ করে পাঠাই একটা বাইরে কামড় পায় বুঝলো আর কি নয় কাজ নয় কোনবি কি করে আমি বসে কি আর বসে সকল আপডেট দেয়া India to our super So parts will so then so logamo paru
My lord, page 14, my lord.
Yes,
It is not a fact that I did not state to the investigating officer in such terms. When my husband reached near the pond situated near our house, accused Shahjahan, Abbas, Abdul Ghaffur, Abdul Malik, Abdul Haq, Toibur, and Abdullah armed with dagger, dao spear, lathi came there and accused Malik and Abdul Haq directed accused Shahjahan to kill my husband. So let us see she has actually stated or not. Let us come to page 49 of the IO.
yes,
Page 49 down, my lord. In the course of the investigation, PW1 it will be, Korimun Nessa did not state as my husband went near the pond near our house, accused Shahjahan Abbas, Abdul Ghaffur, Malik, Abdul Haq, Toib Ali, and Abdullah armed with dagger, daws, lathi arrived there and accused Abdul Malik and Haq ordered accused Shahjahan to kill him. As I rushed there to hold my husband, accused Abbas Ali dealt me with a dow blow on my right hand and accused Abdul Ghaffur dealt with lathi blows on my person. Accused Toiburu Abdul Hai, Abdul Haq, and Abbas attempted to beat me with lathi. As I raised an alarm, the neighboring people arrived there and took my husband and me to Sorbuk Hospital in the vehicle. After assaulting and stabbing us, since the accused person left the weapons, they had brought along my maternal uncle Samsul and took them along in the vehicle in which we had taken to hospital, and Bilal Hussain handed over it to the OC. So this most important part of the evidence, my lord, was never stated before the IO,
Let us see the 161 statement.
my lord.
161 statement where
Yes. Diary, Mr. Das. That is what now is that your lordship will be looking into the diary by invoking the provision of 172(2), my lord. We'll be taking it in a aid to reach that whether this is correct or not. That was what I'm trying to say, my lord, regarding the FIR also. My lord.
can you just read it? Or, okay, and then bring it.
পড়িব দিছে। অসুবিধা হলে দাসক দিলে
It's in Assamese.
Yes, ma'am.
No, did she say accused Malik and Abdul Haq directed accused Shahjahan to kill the victim? Abdul Malik and Abdul Haq. Directed accused Shahjahan. Okay. Yes, Ms. Rakhi, just give it, let him read this portion that we have. Please read out here loud so everyone can hear.
I'm reading out the relevant question. সেইদিনা এই মাটিখিনিৰ বিবাদক লৈ ৰাইজ মেল পতা হয়। ৰাইজ মেল বহাৰ আগতে কিছুমান মানুহে আমাৰ চাৰিআলিৰ তৈবৰ আলিৰ দোকানত চাহ খাব আহে আৰু কিছুমান মানুহ তৈবৰ আলী, মালিক আলী, গফুৰ আলী, আব্বাছ আলী, আব্দুল হক আৰু কেইজনমান মানুহ আসামী শাহজাহান ফকীৰৰ ঘৰলৈ আহে।
So what was that?
They came to the.
Okay, then next.
Before the mail, ৰাইজ মেল বহাৰ আগতে কিছুমান মানুহে আমাৰ চাৰিআলিৰ তৈবৰ আলীৰ দোকানত চাহ খাব আহে। মানে তৈবৰ আলীৰ shop is shown in the
Okay, then next.
sketch nearby the road below. দোকানত আমাৰ চাৰিআলিৰ দোকানত তৈবৰ আলীৰ চাহ খাব আহে আৰু কিছুমান মানুহ তৈবৰ আলী, মালিক আলী, গফুৰ আলী, আব্বাছ আলী, আব্দুল হক আৰু কেইজনমান মানুহ আসামী শাহজাহান ফকীৰৰ ঘৰলৈ আহে। শাহজাহান ফকীৰ house is adjacent to this
Okay,
important.
next.
Next, শাহজাহান ফকীৰ আৰু আমাৰ ঘৰ ওচৰা ওচৰি মাটি বিবাদক লৈ ৰাইজ মেল পতাত কেইজনমান মুখ্য মানুহ নহাত মোৰ স্বামী কাদিৰ আলীয়ে আমাৰ পানী নথকা শুকান পুখুৰীৰ মাজেদি কোন ৰাস্তালৈ মানুহ মাতিব যায়। সেই সময়তে শাহজাহান ফকীৰৰ ঘৰৰ ওচৰত থকা তৈবৰ আলী, মালিক আলী, আব্দুল হকে আসামী শাহজাহান ফকীৰক উদ্দেশ্যি কয় যে এই সময়তে কাদিৰ আলীক ধৰ আৰু মাৰি খতম কৰি দিয়ে।
So what was that?
That means when he went out of his house, that deceased, to call the other persons to the male, this in the nearby shop who were sitting or taking tea, they said Tৈবৰ আলী, মালিক আলী, Abdul Haq, Asami Shahjahan Fokir উদ্দেশ্যে, they told accused Shahjahan to catch him and finish him.
Who told?
These persons who were in the shop of Tৈবৰ.
Who told Shahjahan?
Yes.
The name of those accused, who told Shahjahan?
Shahjahan Fokirৰ ঘৰৰ ওচৰত তৈবৰ আলী, মালিক আলী, Abdul Haq.
Abdul
These
Haq
three
and Malik.
Yes. These three persons. So they instigated.
So that is similar to what has been stated in evidence by PW1. Okay,
But the police says it was not stated, man.
police might have said, but the
No, we don't know,
161 is
but-
there.
Now the evidence is there as such.
Huh?
So these are 161, these are. some-
Yes, but the law requires not what they state later on. But you have got to confront them with that part of the statement which
That
is
was
inconsistent with the evidence.
That
So
was confronted.
so this is, so out there is nothing inconsistent. It is similar.
That is what I said at the very beginning, my lord, that when the documents stays, my lord, that can be looked into. It's not that you have to put questions. I'll also check it from my 161, my lord. Then next, my lord, it is not a fact that I did not state to the investigating officer in such word that the accused person left the weapons with which they stepped and assaulted us at the place. Bilal Hussain brought the weapon by the vehicle in which my maternal Samsul carried us to the police station. So if you look to page 50, my lord, IO has given an explanation. In course of making the statement before me, Korimun Nasser stated, after Abdul Hai had dealt the blow on my hand, I lost my sense and fell down. So he may check it. Verify it.
No, because this aspect is now decided by the learned trial court, that is not an issue.
No, that's why my contention will be that, my lord, there cannot be two part of the story, one edited version or one version. As a whole, it has to be taken into account, my lord.
Next.
It is not a fact that I did not state to the investigating officer in such term when Abdullah hit me on my hand, I fell down unconscious. I do not know what happened later on. So this has also not stated in our FIR, if that was so material matter. It is not a fact that when the accused inflicted cut on me, accused Abbas also sustained cut injury. It is not a fact that I did not undergo treatment in Bongaigaon Lower Assam Hospital. It is not a fact that the accused person neither killed my husband by assaulting him nor caused injury to my brother-in-law Soidul and me and by assaulting us. It is not a fact that on the day of occurrence, the members of the family and I assaulted accused Shahjahan and Abdullah and caused grievous injury on them. And they had to undergo treatment and that a case was filed in this regard. So this is the defense version. It is not a fact that to save ourselves from the case lodged by the accused person, we have lodged this as a bringing false allegation. It is not a fact that I did not know anything about my husband's death. So now the other eyewitness, my lord. PW2, the daughter. She has also her 164 statement. So this eyewitness deposed after 1 month of PW1. Informant Korimun Nesha is my mother. I know the accused person present in the dock today. They live in the neighborhood of my parental home. Around 8 p.m. on 16 to 12, my father Abdul Qadir accompanied my mother Karimun Nesha had gone to call people to attend the mail. And when they reached near the house of accused Shahjahan, the accused person present in the dock today, Malik, Abdul Haq, Gafur, Shahjahan, Abdullah Toibur came there and gherowed my parents. Then on being ordered by accused Malik, Abdul Haq, Gafur and Abbas, accused Shahjahan stepped my father Qadir on his belly with a dagger. My father sustained injury and fell down and was bleeding. Accused Abbas hacked my mother on her right hand. My mother also sustained cut injury. I witnessed the incident. When I raised Halla, my paternal uncle Soiful Islam came to the place of occurrence and then accused Abdul Hai stabbed him on his belly with a dagger. Then he fell down and was bleeding. Then my relative came there and took my parents and uncle to Sorbog Hospital. My father, Kader Ali, was taken to Lower Assam Hospital, Bongaigaon. My father breathed last there. After the postmortem examination there, my father's dead body was brought home and buried. My mother and uncle underwent treatment at Sorbog Hospital. In this connection, my mother lodged an Azahan. Police questioned me. Police brought me to the court to get my statement recorded. I made my statement before the magistrate. Exhibit 1 is the said statement. Exhibit 1 and 2 are my signature. So, my lord, this witness was examined after the examination of her mother after 1 month. So now she improvised and gives a story as her mother told in order to corroborate her part of the story. But she cannot escape what was stated in her 164 and her earliest prior statement under 161. No doubt how much they want to improvise the case, my lord. I'll show one by one. But here I'll pause for a moment and say that this 161 statement of this girl was recorded after 2 days of the occurrence. And her 164 was recorded after 15 days of the occurrence. So there was a belated recording of the statements. 161 after 2 days of the occurrence. And 164 after 15 days of the occurrence and 13 days from 161. My friend can check it. Check. Kindly check it if I'm saying correctly. Huh? My submission may kindly be verified. So there was a scope for embellishment. That is my response submission. So now we'll go to the cross-examination. And one more legal submission which I'd like to make vis-a-vis the 164 statement. My lord, this 164 statement has simply been marked as Exhibit 1. Whether that will be sufficient without stating the contents what was stated in her 164. Merely by marking a document does not amount to proof of the contents of the document. One has to give the gist. Yes, while I was being produced before the court, I stated this in this manner before the magistrate.
Who exhibited?
The girl herself. Yes.
PW.
Yes, PW husband. My contention, my lord, my submission before your lordship, that it was a mere marking of the document. It does not prove the contents of the document that she actually stated this thing before the magistrate. So for that, my lord, the law is that, my lord, that one has to give the gist of the 164 statement. Yes, I stated before him like this. Just because merely marking will not do, will not amount to the proof of the contents of the document, my lord. One has to bring the gist at least, not the whole, my lord. That I will give the legal proposition, my lord. Whether mere marking of a document is sufficient to prove the contents of the document, my lord. My lord, cross-examination, my lord. My father had two brothers, my aforesaid uncle and Sadek Ali. Accused Shahjahan and Toibur are my mother's brother, probably. Your lordship can verify it, my lord. I have written from my own instruction. Accused Shahjahan and Toibur are my mother's brother. They are not my mother's own brother. They are my relatives, maternal uncle. Now, different uncles come in. Accused Shahjahan and Toibur are the sons of the second wife of my maternal grandfather. The school where the male was supposed to be held was near the Chowk and Sapur village. The school is adjacent to our house. The house of Shahjahan is situated in between. The distance between the school and our house is 20 feet. There is a small lane running east-west leading to the school from our house. One can reach the school by that road and then the main road running from south. My father called the people to the mill. Only 2 to 3% came to the mill meeting. The rest of the person did not turn up till then. The people called to the mill meeting were our fellow villagers and relatives. The 2% who came to the school to attend the mill were Bilal and Inu. Now, if your lordship will go to their evidence at page 41, we'll see that they comes to the meeting, Bilal comes to the meeting at 3:30 p.m. and the occurrence took place at 8 p.m. And Inu not examined, though he was an eyewitness of the case. They are our relative. They have witnessed the incident. After the injured person were taken to the hospital, I became unconscious. Sapur Chowk is about 100 feet away from Shahjahan house. The school is adjacent to the Chowk. Police recorded my statement after 15 days of the incident at Sorbuk police station. Police had not recorded my statement prior to that. I do not know who identified the place of occurrence to the police. So the place of the occurrence is itself in doubt, my lord. At the time of the occurrence, my father was clad in a white vest and a pair of black trousers. So if we look into the, though it may not be material, my lord, but the story is given in a different manner, my lord, by the PW1, my lord. Sorry, it's on page 13. My father was clad in a white vest and a pair of black trousers. PW1 equals. The dagger with which Shahjahan has stabbed my father was about 3 feet long. The dagger pierced through about 6 inches deep into my father's belly. My father's vest got torn. The trouser and vest got stained with blood. Blood fell on the ground too. So bloodstained art was also taken, but no report. Keep in. Okay. I did not see the length of the Becky down with which accused Abbas assaulted my mother. The blood coming out from the injuries of my mother and uncle Saiful fell on their clothes and on the ground, and the trouser of my uncle got torn. My uncle was clad in a pair of blue trousers. I know nothing with regard to the seizure of the police. Police came to the place of occurrence 3 days after the incident had taken place. So from her version, prosecution version, it is coming, my lord, that the police comes to the PO after 3 days. So what type of investigation will be that, my lord?
Where is that?
Police came to the PO, place of occurrence, 3 days after the incident had taken place. I did not go to the place of occurrence when police came to the place of occurrence. There has been dispute between accused Shah Jahan with us with regard to land property since many years prior to the incident. And on the day of the occurrence, my father called for a mail meeting in that connection. I did not state to the investigating officer. So here she admits. My father Abdul Kader and my mother Karimun Nesha had gone out to call people to the meeting. And when they reached near the accused Sarjan house, the accused Malik, Abdul Haq, Gafur Sarjan and Abdullah and Toibur came there and out my parents. In my statement to the investigating officer, I did not state in such term. So this is admission coming, not contradiction. She admits that she has not stated. In such term, accused Malik, Abdul Haq, Gafur, Abbas gave direction to Shah Jahan. This exhorting my lord. In my statement to the investigating officer, I did not state in such words. First accused Abbas dealt blow to my mother by means of dao, and then Gafur assaulted my mother by means of lathi, and then my mother fell down unconscious in the middle of the pond. In any case, that is acquitted. My uncle Sofikul Islam, PW4, reached the place of occurrence about a minute after my parents had fallen unconscious.
No, one thing,
My lord.
page 18, the last 2 lines.
Yes, my lord.
In my statement to the investigating officer, I did not state in such terms, accused Malik Abdul so gave directions to Shah Jahan to do what?
But
This is blank.
that exhaustion line is not there.
But it pertains to what? Pertains to what?
But I'll try to find it out.
This evidence is translated?
Yes, my lord, this is
translated.
translated. We can check it.
So what does it? So,
Mm.
তদন্তকাৰী বিষয়াৰ আগত সাক্ষ্য দি এইদৰে কোৱা নাই যে আসামী মালিক আব্দুল হক গফুৰ আৰু আব্বাছ আসামী শ্বাহজাহানক হুকুম দিয়ে।
what is silent?
But it is there in the 161. 161 is the first one.
So that is admission from her part. She admits that she has not stated as such.
To do what? But then that also is unclear.
Oh, my lord. No, that
No,
exhaustion
the
passed, my lord.
direction is not, the direction has not been spelled out
Yes.
in the cross examination.
No, that was confronted from her chief, my lord. In her chief, she says, my lord, that on being ordered by accused Malik, Abdul Haq and Gafur and Abbas Ali, accused Shah Jahan stepped my father. Earlier it was 3%, here now they have brought in 4%, my lord. So one incident cannot be viewed. Mother said 2% and here there are 4%. And 164 contradiction I will show, my lord. In my statement to the IO, I did not state in such terms that Malik, Abdullah, Gafur and Abbas gave direction to Sadan. It's regarding giving direction to kill.
No, that is silent. And it's in inverted commas. Mind
My
you.
lord.
It's in inverted commas. If it was not in inverted commas, maybe we could have speculated, but when it is inverted commas specifically, no specific question had been asked. with regard to whether the direction to kill had been given.
No, that is the trial court ought to have recorded it in a better manner, my lord.
Maybe, but then we are bound by what is recorded.
In my statement to the IO, I did not state in such term that accused Malik and Iman gave direction. It's regarding giving direction.
Yes, but then
Inverted
the
comma.
direction to what effect? We do not know.
Inference will be to kill only.
It appears that with direction to kill so and so. But then can we go beyond what is written? Especially when it is in inverted commas. If you see the entire evidence,
No,
it-
regarding
that
giving,
inverted commas is hardly there. It's specifically here.
but it things comes out is that regarding giving direction to Shahjahan. That direction, if we look into my lord at page 16 of our deposition, direction to kill. Accused Shahjahan stabbed my father in his belly. It is goes like this, then on being ordered by accused Malik, Hawk, Ghaffur, Abbas, accused Shahjahan stabbed my father.
Anyway, next.
In my statement to the investigating officer, I did not state in such word. First accused that I have read, my lord. Now the important part, my lord. My accused of Uncle Safiqul Islam, that is PW4, reached the place of occurrence about a minute after my parents had fallen unconscious. We took my parents to the hospital while they were still unconscious. Let us just pause for a moment and look into PW4 at page 23, my lord. He claims to be an eyewitness. Court authorizer. কথাখিনি ক'ত আছে? My lord, the informant is my relative. He says, the girl says that he comes within 1 minute. The PW4, my lord, the informant is my relative. I know accused person present on the dock today. The incident took place around 8, one day at about 3 years ago. At that time, I was at home. Hearing Halla on the bank of Kadir's pond, I came there and saw Karimun Nesha and Kadir lying on the dried pond. I saw blood oozing out from Kadir's chest. Some other person had come there before I reached there. Having seen the incident when I raised Halla, Abdul Hai, who is present in the dock today, stabbed me on my lower abdomen with a dagger. Accused Toibur inflicted cut near the wrist of my right hand with a dowel. Blood came out injuries. People came and took me to Sorbog Hospital. My injuries were bandaged there. And
Who is he? Who is this person?
My lord, the girl, this daughter says that the uncle Sofiqul Islam reached the place of occurrence within a minute.
Saidul Islam.
Yes, PW4. So he is also claiming to be an eyewitness to the occurrence, which he cannot be. That is what I'm trying to show from his evidence, my lord. When he came. Absolutely. After the occurrence was over, he came, so he cannot see the occurrence, my lord. He comes after the occurrence was over, my lord. Exhibit 1, the statement was written as per my version. I did not state in Exhibit 1 statement that the accused person Gherao surrounded my parents in front of the house of the accused. So this your lordship can verify it from the 164, my. Because she has not stated what she has stated in her 164, but she was contradicted in her 164. In my statement, Exhibit 1, I did not state that accused Abdullah stabbed my uncle Sofiqul Islam on his belly with a dagger. In my statement, Exhibit 1, I did not state when I raised Halla, my uncle Safiqul Islam came to the place, the house of the accused.
No, out here, PW4 does not say that he is eyewitness.
No, the girl says, no, my lord, that he comes immediately
The
after.
girl says that Saiful Islam reached about a minute after parents fell unconscious.
So
he also
if
does
it is
not-
within, so If he is not a witness, that means by seconds, the case was over.
Right? In respect of,
The whole incident.
Why?
Because he comes within a minute, 60 seconds.
he came after the incident.
That is what I'm saying.
Yeah.
That. So this girl, daughter is speaking a lie. He cannot come after a minute. If he comes after a minute, he must have seen the occurrence. He
No,
must have,
no, she said.
my uncle,
About a minute after my parents had fallen unconscious.
Yes.
Now, when you see PW4 at page 23,
yes,
he says that
he was at home.
hearing halla on the bank, I came and saw Charisma lying on the dried pond. I saw blood oozing out from Kader's chest. He does not say that he saw the incident.
But he was also assaulted at the same time, he says.
Maybe assaulted later.
Uh.
This does not. This only proves that he did not see the assault on PW1 and the deceased. How does
That
this-
is what I'm trying to say, my lord. The judge dealt with him as if he was an eyewitness to the occurrence.
Okay, okay.
That's why I'm showing it, my lord, that he cannot be an eyewitness
And
because he is a victim also. He sustained injury. Now in a one,
let us see the judgment. Where does it say?
my lord, judgment, these witnesses were taken into consideration. my
No,
lord.
no, let us see where does the learned trial court in the impugned judgment say that he is an eyewitness?
No, 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 not directly, my lord.
Then neither here nor there.
My lord, the PW4 has been taken into consideration, but
No,
what,
PW4, but then where does the learned trial court say that PW4 was the eyewitness to the murder of the
no,
assault on the deceased?
I'll
and
read, my lord, page 87, para 20.
Page 87.
PW4 Saidul Islam deposed that informant in his relative and he knows all the accused person. The incident occurred about 3 years back at about 8 AM. At that time, he was in his residence. Hearing hue and cry on the side of the pond of Kader, he immediately rushed there and saw Korimun Nesa and Kader lying with huge bleeding from the chest. In the meantime, other people also gathered. According to him, he was also assaulted by accused Taibur on his right hand and he was also taken to
So he's not
hospital.
eyewitness.
No, this is the evidence.
He's the eyewitness only with regard to the assault made on him. That's all.
My lord, this is the evidence quoted. So far I'm trying to show, my lord, that they are giving a fantastic stories, my lord, which is beyond compassion. Why I say? Because immediately the PW says immediately after assaulting, they left the place. Then where is the question of
Which
meeting?
PW said that?
PW1, my lord.
No, there's nothing there.
I'll try to show it, my lord. My lord, will come to 45 of the judgment, my lord, regarding
Yes.
as regard the occurrence. My page 96, para 45 of the judgment, my lord. I think by this observation, the judge has taken it as a eyewitness, my lord.
PW1 and 2 only. Then
Yes.
there's nothing.
No, no, as regards occurrence, PW3, 4, 6, 7, and 8 have given evidence. And after due consideration, this court do not find any grounds to disbelieve or discredit the evidence with that of the eyewitnesses account of PW1 and 2, who are wife and daughter of the deceased, only on the sole ground of being relatives. So the evidence of 1 and 2 are very much natural. Then again at para 36. Oh, no, that is. Hmm? Now I have to quote for each judgment. Says corroborates by other witnesses, like. So ultimately in the judgment, basically two eyewitnesses account was stated by an other lending support.
Yes, then
My lord. Then her 164 statements, my lord, contradicts what he has stated before the court, my lord, regarding the.
one
fighting part.
sixty-four statement.
Yes, my lord. Page 19, my lord.
Yes,
Exhibit 1 statement was written as Marmara. I did not state in Exhibit 1 statement that the accused person out my parents in front of the house of accused Shah Jahan. I did not state that accused Abdul Hai stepped my uncle Sofikul on his belly. I did not state that when I raised Allah, my uncle Sofikul Islam came to the place of occurrence. The house of the accused Abdul Haq, Ghaffur Malik are far away from the place. Except accused Shah Jahan, we have no enmity with the rest of the accused persons. Madam. So rest that there were land disputes, he denies and everything, madam. Then the doctor, my lord, PW 3, my lord. Doctor finds only one injury, my lord. And this postmortem was carried out as per GT entry 470. On 16/2, I was working as senior medical health officer, Bongaigaon Civil. On that day at 3:30 p.m. I have conducted the postmortem examination on the dead body of Abdul Qadir, as at about 42 years in connection with spoke PSGG entry number 470 dated. My lord, just one line, my lord.
yes,
My one line, my lord, I'll just put, a deep sharp cut found on the right lower part of the chest, length 3 inch, breadth 1 inch, depth 4 inch. Then laceration wound on the right elbow joint. So these are the two injury. One is that fatal injury is that one, my lord. In the opinion part, my lord. In my opinion, the case of the death is due to shock and hemorrhage as a result of the chest injury, which is antemortem in nature. So all the time the witnesses are saying it is on the belly and on the stomach. It is chest is on the upper side, my lord.
that is hardly get to hear.
I know your lordship would say, so I will not say much. But the facts remain, my lord. Even eyewitness one should be accurate, my lord.
To the best of how much he can be accurate, it depends.
Chest, belly, stomach are three different.
No, but then supposing it is here,
Chest is always on the upper part, in the
yes,
chest.
but supposing it is here,
And belly
where
is
the
on the
ribs are.
lower part, my lord.
what do you call the portion where the lowest ribs are? You call it the chest or the stomach? It is not the stomach.
Belly, stomach, one thing, my lord. But
Supposing in the
chest
lowest
is on
rib,
the upper part.
you see, when the lowest rib is here, when the lowest rib is here, and it is in this area, suppose what will you call it? According to you, what will you call that area? This area, what will you call it?
Stomach, my
Stomach.
down portion.
So you can call it stomach, you can call it chest also. I mean, it is, you see, it is
Chest is in the
subjective.
middle of
It
the
is
torso,
subjective. It is subjective. Anyway,
Anyway,
that is neither here nor there.
because in a criminal case.
The
my lord,
fact is that
everything
there
should be-
was an injury, it happened there. How does it make it?
There should be specific, my.
Okay,
In
please.
my opinion, the cause of the death is due to the shock and hemorrhage as a result of the chest injury. Accordingly, I have submitted the postmortem. Now the cross, my lord. The deceased was sent for postmortem from Lower Assam Hospital and Research Center, Bongaigaon. I have not received any injury report from Lower Assam Hospital and Research Center, Bongaigaon. On requisition, I have conducted the postmortem report. As such, I have mentioned the GD number such. I have not mentioned the address of the deceased Qadir Ali in Exhibit 2. I do not know late Qadir Ali personally. Injury number 2 is laceration injury was not caused by sharp weapon.
Do we need to read this?
My, yes, a bit necessary, my lord. Cross is a good damaging to the doctor's evidence, my lord. Your lordship will just take the next line, my lord, page 22, my lord.
Yeah.
I have not found any penetrated injury on the lower part of the chest. So that is why the cross was made, my lord. Lower part, my lord, the whole story is saying that it was on the belly lower part. So there was no penetration injury to show that there was stab injury. I have mentioned the size of the injury on surmises. I have also not mentioned the duration of the injury, whether it was face or wounds. I have not mentioned the time since death. So these are the lessons, minor. I do not know how many numbers of ribs are on the dorsal or frontal side of the chest. I also do not know the distance difference in between two ribs. I have not found any injury in the ribs of the deceased. it is not a fact that I have not conducted the post report on the dead body of Kader Ali in connection with this case. So the doctor himself doesn't know, my lord, when there will be rib injury, my lord, it will touch the ribs, my lord. So that thing, it has come in the cross examination, my lord. So now which one to be taken, my lord, whether it's belly or in the ribs, my lord. Then coming to PW4, my lord, Saidul. He comes after the occurrence, but yet he is claiming to be a injured witness, my lord. The informant is I have read the chief, my lord, already. I'll just take your lordship to the cross part, my lord. The place of occurrence half a furlong away from my house. On the day of the occurrence of Mel was going on in a school near the road.
Yes,
What is the name of PW4?
My lord, Soidul, my lord. Saidul Islam.
Shahidul,
This way it is written, my lord, Soidul Islam.
but the PW2 says her uncle's name is Saiful.
Maybe. So who is this Saiful now? Not examined, not examined.
So
Saiful
she,
is not examined.
whether she was referring to PW4.
It looks like because he says that immediately he came to the occurrence of this, what the girl was saying. So
who
this,
is Saiful is Saidul? Any clarification on that? No clarification. Just see the reports. Who is PW4?
because this is translated typing, my lord.
Might be a typographical error. Huh?
PW4 is Saidul.
Saidul. And this
Paper book says Saidul,
PW2
says Saiful,
talks about
Saiful Islam. So then the judge writing of the judgment will be also wrong, my lord, because PW4 has been referred as that uncle, my lord.
no, let us see in the evidence whether it is Saidul. Actually, there might be a typographical error in the translation.
In Assamese end of PW2, it is written as Pro 1 Javan Mundit Mohamud Sasa Saidul Islam.
Saidul.
So it is
So it should be Saidul.
Saidul. In translations.
So this is a
That translation book.
just a translation. There's a mistake.
So here he comes up with a different story, my lord. The place of occurrence is half furlong away from my house. On the day of the occurrence, a male meeting was going on in the school near the road. So what is this, my lord? The earlier two witnesses say that husband was going to call meeting, my father was going to call meeting. Now this person who comes immediately after.
And he has not seen the incident, and the injury against him, those has not been accepted by the trial.
This is regarding meeting, he's saying specifically terms in the cross. The meeting was
So-
going on.
so he's not a reliable
On the
witness.
contrary, PW1 says, my husband was going to call people. So three versions are coming. So when the versions are not inconsistent, my lord,
That is neither here nor there. Once an incident
because the
takes place,
genesis starts from there only. Meeting, my lord. And 40-50% were already there. So where are those witnesses?
no, those were because of the halla and all
No, your lordship cannot inference that way, my lord. That evidence should
So
come, my lord, in the
then
record.
you cannot accept his evidence also.
Definitely not, my lord.
You can accept or
So
you cannot
it-
accept.
the trial court took credence of his evidence that he also supposed the person of PW1 and 2.
This is neither next issue. Let us go. We've got no time.
Criminal appeal, my lord, 7% are on the gallows, my lord. There is a small lane leading to the main road from this is Kadir's house, and he used the lane for to and fro. It was a dried up pond and in depth was about 7 to 8 feet. The pond was a long one, but I do not know how long it. The digger which I was stepped was about 1 feet long over and 1.5 inch wide. About half an inch of that digger pierced into my belly. The people present at the place of occurrence saw Abdul Hai stabbing me in my belly. But not a single witness. The dao which was cut was inflicted in my right hand in about 1.5 inch long with the handle. The people present at the place of occurrence saw accused Toibur causing injury to me. Both my injuries were bandaged at Sorbonne Hospital. At the time of the occurrence, I was clad in a pair of trousers. On being stabbed with a dagger, my trouser got perforated, torn, and stained with blood. I showed the trouser to police. Police did not see the same. So, my lord, he is giving a narration that all the persons present there saw the occurrence. So, where are those persons, my lord? So, this cannot be edited version, my lord. It has to be taken as a whole, my lord. If the earlier occurrence is there, his occurrence is to be also true, my lord. But the court found there is no sufficient materials to hold that there was any assault on his part. After 3 days of the occurrence, police questioned me. I gave my statement. It is not a fact that neither accused Abdullah stabbed me in my lower abdomen with a dagger, nor accused Toibur inflicted cut injury near the wrist of my right hand with a dao when I raised halla on seeing the incident. I do not know about Abdullah's wife lodging any case against me and others. It is not a fact. We tried to show that there was a case, but unfortunately we did not discharge our duty, my lord, no doubt, my lord. But there was something between the two parties, my lord. That's why these suggestions were thrown time and again. It is not a fact that on the day of the occurrence, about 10 other persons and I together assaulted Shahjahan, Ali, Abdul Hai, Rohima, and others and looted their house. It is not a fact that I did not sustain any injury the way I have deposed today in the court. It is not a fact that I have adduced false evidence for the sake of the informant's complaint. Because our story was that, my lord, they came and vandalized the things, my lord. As a retaliation measure, there was a pre-fight fight. And in that even, something happened. My lord. Then PW5. He claims to be an eyewitness, but it's impossible that he will see it. I'll show from the evidence. Informant Kariman Nessa is my sister-in-law, elder brother's wife. I know all the accused person present in the dock today. The incident took place around 8 to 8:30 on 16 to 12. Kariman Nessa husband Kader was going to the road near through the middle of the pond situated in front of the house. Then I was inside our house. Hearing a commotion, I went to the bank of the pond of Kader and saw my elder brother lying in the middle of the pond. At that time, the pond was dry. Blood was oozing out from the left side of my elder brother Kader's abdomen. Shahjahan stabbed my elder brother Kader with a dagger Karimun Nessa was trying to hold. So how can he see this occurrence, my lord? Was trying to hold her husband Kader and save him from Shahjahan. Accused Abdul Hai, Fakir, Abdul Haq and Abdul Malik were at the place of occurrence. Someone dealt cut blow on the right hand of Karimun Nessa causing injury. He doesn't know. If he's an eyewitness, he would have seen it. When Saidullah, then probably this is PW4, arrived there, accused Abdul Hai Fakir stabbed him in his lower abdomen with a knife. In order to save, when Saidullah tried to grab hold of the knife remaining in the hand of Abdul Hai Fakir, he sustained cut wound in the right palm.
So he's not an eyewitness.
Oh, he's not an eyewitness. He cannot be, my lord.
Okay,
Then, my lord, all are doubtful witnesses, my lord. Then come PW6, my lord. Saw the occurrence of Triswa, which is completely false, my lord. So what I am trying to build upon, trying to impress upon your lordship is that a false case is being built upon the accused persons, my lord.
PW6.
6, he is again claiming to be an eyewitness, which he cannot be, my lord. I'll show how he cannot be, my lord. I know informant Karimun Nessa and also know accused Malik, Khalek and all these accused present in the talk. The incident took place at 8:30 on Iman. I was in my shop situated on the bank of the pond of Kadir. Then Kadir Ali was going through his pond to attend the mail. He was going to attend the mail, not calling for the mail people. The accused person and I above name have assembled in the house of Shahjahan. Coming there, that is the PO, all the accused person wailed Kadir and accused Shahjahan stepped Kadir on the right side of the abdomen with a dagger. Kadir sustained bleeding injury, then Kadir fell down. So here is no exhaustion, my lord. That's, they said this. The incident took place in the middle of the dry pond itself. No sooner had Kadir fallen down, his wife arrived there and held him. So if this witnesses in seen the occurrence, so the wife was not along with this is my lord. Because PW says that I was following my husband for going to call people. And this witnesses says my lord, that only Kadir was the present. And Kadir was given blow directly by Shahjahan. So where is that two-person exhorting, my lord?
Now, what does the trial court say about PW6?
My lord, that was only taken into account, my lord. His evidence has been quoted, my lord.
Not taken into account.
No, only quoted his evidence, my lord.
Yeah,
Nothing
not-
as such, because
no.
trial court heavily relied upon 1 and 2.
Right.
But that cannot be read in isolation. The evidence as a whole of all the deposition that has come and brought into the record, my lord, has to be taken as a whole, my lord. You cannot segregate those favoring the version of the prosecution is to be taken to find the guilt. Because evidence appearing on the record as a whole is to be taken into account, my lord. Then Kadir's wife comes, my lord, after the occurrence was over. Dealt with such and such, a Maruti car was arranged and injured, such a police questioned me. I do not remember the date of the man, or not there. I have no shop by the side of the road. I was sitting in the shop of Akbar Ali. The tea stall and the grocery are being run under the roof. The choke is in front of the shop belonging to Akbar. You know, he says, I was witnessing the entire incident from the road along the bank of the pond. My house is 3 houses apart from the place of occurrence. The house of accused Shahjahan and LP school are there in between. Kadir and the main road, and no other person is there. Beside the accused persons, of 5 to 7 persons were present at the place of occurrence where I reached there. Those 5 to 7 persons were Mohidul, Akbar, Shahjahan, and another man, not accused Shahjahan, Sohidul Islam, Akil, Kalam, and Faisal. All these are not examined except Sohidul Islam. Those people witnessed the incident. At the time of the incident, accused Iber's tea still was open. Akbar Ali witnessed the incident. I did not notice where the employees of the shop witnessed the incident or not. The mail was supposed to be held in the shop of Akbar Ali, whereas in the others version, the mail was supposed to be held in the school. And here, so much of person has witnessed the occurrence, my lord, except Sohidul, my lord, Sohidul Islam, PW4, none has been examined. Though those persons witnessed the incident, he clearly says, my lord. I witnessed the incident from a distance of 2 nulls only. I am not aware of Julekha Begum lodging a case against me. This is Kadir was cleared in a pair of trousers and a shirt. Okay, fine. In course of the statement before, I did not state I was in the shop located at the bank, my lord. I have no. My lord, if your lordship will see page 31, he is contradicting himself, my lord. I have no shop by the side of the road. I was sitting in the shop along with Akbar Ali. The tea stall and the grocery shop are being run under the same roof. And here he says in his chief opening line, I was in my shop situated in the bank of the river pond of Kadir. And during 161 also he has not stated. In the course of my statement before the IO, I did not state that I was in my shop located in the bank of Kadir's pond. But say that I have witnessed the incident from the bank of the pond. Then PW7, my lord, Shahjahan Ali, he is not an eyewitness. He comes after the occurrence was over. I know informant Korimun Nessa.
Hearsay evidence.
Oh, yes, my lord. After he comes, my lord. Then hearing
So
a commotion in the
Then what
right,
is the point of reading?
right pond, people Shahjahan has assaulted Kadir, my lord.
Then we go to 8.
I did not see the person who caused the incident, my lord. Then PW8 is one Mofidul Islam. the driver who carried the deceased and the injured to Bongaigaon.
Here, say again.
Yes, no, one thing is there, my lord, Caesar witness of the material exhibit Dow. PW 9 page 41,
Caesar witness of thou.
yes. I'll read that line, my lord.
Yes.
When Somsul Haq handed over, my lord, in the middle, my lord.
Yeah.
When Somsul Haq kiman witness, Somsul Haq not examined. Somsul Haq was not examined, my lord. When Somsul Haq handed over the weapons which he had put in my car to police, the latter seized the same and obtained my signature in the seizure list. Exhibit 3 is the seizure list, wherein Exhibit 3(1) is my signature. After the inquest being done on the dead body in the lower hospital, Assam Hospital, my signature was obtained in the inquest report. Exhibit 4 is the inquest report, wherein Exhibit 4 is my signature. Material Exhibit 1 is the Bekida with handle. Material Exhibit 2 is the sword, and Exhibit 3 is the knife with wooden handle. Somsul Haq handed over those articles to PS in my presence. So 3 types of instruments are being projected that has been used in the offense. But the evidence and the medical report says only one injury. So where from all these things come, my lord? The police don't take it. They brings it and says that these are the weapons that has been used. But these weapons has got no connection with the killing of the person concerned here. So from where all these other articles come in, my lord? So it is just a got up story, my lord. They are trying to project it. Why all these other weapons, and why the police did not collect the weapons from the PO when they at the first time came at 8 o'clock, my lord? If it was lying there, my lord, it was the duty of the police to seize those articles, my lord. But here the informant party seized it, takes it to the police station and gives it. And the person who gives it, Somsul Haq himself, is not examined. Then what will be the veracity of this giving of the document? And how did this connect with the killing of that person, of the deceased of this case, my lord?
So what are you trying to say?
But I'm trying to say, my lord, that this weapons story, they want to exaggerate it. That saying that all these weapons were used by various people, these and that, as they are narrating from time to time.
The only issue is the death
So
of the
there's
deceased.
nothing left, my lord.
No,
So we are having many a version.
no, there's the death of the deceased by a weapon.
Now, who killed it? That person
So
should be
the
hanged.
weapon is there, it has not been recovered. But when there is an
So they
eyewitness,
are bringing it, projecting it, as if we have used it, the accused persons, which is not correct, my lord. That is my respectful submission. They want to project it as if these weapons were used by all the accused person. But the deceased received one stab injury on the chest. Forget the belly part, stomach part. I'll not impress upon your lordship, because your lordship, right? It may be upper, lower. One may see it this way or that way, my lord. But the facts remain now that there was one single injury given by Shahjahan. Why are there others thing? Nothing comes out. Assertion, if your lordship believes PW6, then who is claiming to be an eyewitness, Chan Mia, my lord? He says nothing happens. Wives come subsequently after the occurrence was over. So her deposition will carrying no meaning at all, my lord. If PW6 eyewitness is to be believed, just because she is the wife of the deceased does not give her a license to say that she is the believable witness, my lord.
but who else will come?
My lord, there were lots of people. If your
But
lordship
then,
take one account, there are 40 to 50 people
Why
already
shouldn't we
in the
believe
meeting.
a relative?
No, my lord, this was a village area. It's not an isolated area. Had it been an isolated area, apart family members, none will come. Had it happened in the inside of a house, my lord, the family members will come. But here it is in an open space. Once it is in the dry up pond, and the 8 o'clock information says in the paddy field. So how does the occurrence place sit? Where is that blood stained earth? What is the report that has been taken into account? Nothing has come, my lord, on records, my lord. So the place of the occurrence itself is doubtful. They are building up their case as an afterthought measure and improvising the case as when the case progress. The 161 statement of the daughter was taken after 15 days of the occurrence. So they got much time to improve their case, my lord. The daughter comes after 1 month of the mother's deposition. So by that time, she has come to know what a mother.
In the
has
same manner,
My
then evidence are usually taken after years. They could have, it can be always improved.
Which evidence, my lord?
Evidence in the trial court.
Definitely. So that's why the Honorable Supreme Court has come up from the mouth of Justice Sapruz, my lord, that we should make a calendar, that eyewitness account, Caesar witnesses account will come in a block manner, my lord. So
then
well, I'll finish just with the evidence of the person concerned, my lord. PW 8, I have taken it. PW 9, my lord, page 41. Is another Caesar witness of death materials, my lord. On around 3:30 PM on that day, on hearing that Kade's dead body was brought to Sorbu police station. So the wife says we come directly to the home, my lord. And here it is said that it has been brought to Sorbu police station. So which version to be taken as true, my lord? I went there to see it. I saw the dead body of Kader in Sorbu police station. And the wife said that they were directly brought from the hospital to home, and thereafter in the night he was cremated. Then one Samsul Haq, not examined of Sahapur, handed over 3 weapons, that is dagger, dao, and a knife to the police in my presence. Police seized this article in my presence and obtained the signature in Exhibit 3 in the Caesar list. So Exhibit 3 is the Caesar list, my lord. Wherein is my signature I have seized. Preparing Exhibit 3 in my presence, police obtained my signature therein. Karimun Nessa and Samsul were present there. So now Karimun Nessa is present in the evening, my lord. Before going home, she was present in the police station because this is the 3:30. How can she be present in the 3:30, my lord, when the postmortem itself was going on at 3:30? Your lordship.
Small,
No, these are not small, my lord.
discrepancies
My
with
lord, my
time.
lord. Just a moment, my lord. This postmortem took place at Bongaigaon, which is not less than 60 kilometers or so. And they comes with a dead body in the evening, 6 o'clock at home. So how can this 3:30, my lord, this PW1 be present at Solbo PS, my lord? It's not our defense evidence or our cloth. From the chief itself is coming. 3:30, the wife cannot be present, my lord, because if the medical postmortem is looked into, my lord, he clearly said that he started the postmortem at 3:30 itself. And the wife says that I accompanied the dead body from there, my lord. No, छोटा से 3:30 है तो। यही आते हैं ऐसे। On 16 April, I was working as senior health officer Boinga. On that day at about 3:30 PM, I conducted the postmortem. At page 20. So here, the story goes from PW9's deposition around 3:30 on that day. On hearing that Kade's dead body has been brought to Sorbuk, I went to see it. Postmortem is going on, my lord. How can the 60 kilometers they travel, your lordship, to this area, my lord? And 3:30, how can the dead body come to the police station, my lord? Then PW10, my lord. Akbar Akhan, my lord.
Yes.
He is a tea stall owner. Then from him, your lordship will see that PW1 and 2 were never present at the time of occurrence, my lord. I know informant Korimun Nessa and also no accused person present in the dock today. Around 8:30 to 9, one day some 4 years ago, I was in our tea stall, some grocery shop at Sapur. Then I heard a commotion in Kader's dry pond behind our shop, where I went there and saw Kader lying in the dry pond and screaming, I am dying, I am dying. I saw bleeding injury on the abdomen of Kader. Then I called some person present in my shop and asked them to take Kader to hospital. Then Somsul Haq arranged a vehicle and sent Kader to hospital. Then I went to Sorbuk police station, was accompanied by other person. Kader was not treated in Sorbuk hospital and was taken to Lahore hospital. Therefrom, some 3 to 4 hours after that, I heard that Kader had passed away. That's all I have to say. The place of occurrence is about 2 furlongs away from my shop. At that time of the incident, accused Tiger and tea stall near that of mine. No other shop was there during that period. At the time of the incident, Tiger's shop was open. Except for Kader, nobody else was present at the place of occurrence. So this is coming from the prosecution witness, not our defense witness. The prosecution witnesses are giving version after version, and this is the real story, my lord. They have developed subsequently. That is what I'm trying to impress from the very beginning, my lord. That this is the actual occurrence. Nobody has seen the occurrence. As an afterthought measure, then FIR was filed. At 8 o'clock, one person sends information to the PS that 2 persons are lying injured, my lord. One was found at the spot when they comes out at 9:10 AM. Police finds, my lord. So these witnesses will not get quite away, my lord. This is also the evidence appearing from the prosecution side. He is not declared hostile. The prosecution has not cross-examined him, that you have given a different version in your 161. So his evidence remained intact, my lord. So all this evidence has been read vis-a-vis the other evidence appearing therein, my lord. Then PW11 is the IO of the case, my lord. For the time being, if I skip I skip IO, my lord, we can come to PW12, the person who produced the GD entry, my lord. Pranab Kumar Soikia, on 6/12/22, I was working as a OC Sorbuk police station around 8:40 on the day. One Fazal Haq of Shahpur under Sorbuk PS informed me over phone that following an alteration over some land dispute, some members of 2 families of Shahpur armed with dows and daggers involved in a fight. As a result, 2 persons were lying in the field injured at the police station, and that police should go there. Accordingly, I made Sorbuk PS GD 470 and instructed ASI Dilip Talukdar to go to the place of occurrence. Exhibit 5 is the said Sorbuk PS GD register number such and my signature thereon. Then ASI Dilip started proceeding to the place of occurrence along with stuff. I made GD 471 to that effect. He proceeded to the place at the occurrence at 8:42 AM. This GD was not exhibited, my lord. Around 9:10 on 6/12, ASI Talukdar informed our phone that a man smeared with blood.
Which one was not exhibited? 407.
No, 471. Subsequent, that
471.
police coming out. 470, 71, 72, 73 has been exhibited, my lord. 71 GD has not been exhibited. I was lying at the place of occurrence in an injured state that he was struggling with his life and a tense situation has arisen at the place of occurrence. Accordingly, I sent aside Deodhari Das to the place of occurrence and made GD 473. Exhibit 5/3 is the GD, number 470 is my signature. The investigation of this case, your lordship will see the important line, my lord. The investigation of this case started on the basis of the GD number 470 dated 16/2/2012. In the GD, I have not mentioned the phone number of the person who have furnished the information regarding the incident of a phone. This is a big latches, my lord. In the GD number 473, I have not mentioned the phone number SI Dilip Talukdar. Okay, that is not necessary because the person is a police, my lord. I have not mentioned the detailed description of the place of occurrence in the same GD, where it has happened. And the making of GD, I did nothing with regard to the investigation of the case. So the GD entry, the first point, information exists before the police in a neutral manner that there was fight between two groups in the locality regarding some land dispute. It is not the way it has been projected in the subsequent FIR, which was belatedly filed after 8 hours. So they got plenty of time as an afterthought measure to file the FIR of the case. So shall I continue?
How long would you take? 5 minutes?
No, I have to put the legal submission and all. If your lordship bears with me, if Monday, if your lordship is sitting,
You're fixed.
No, I'll take 1 hour, but at the most.
It's
Monday
not-
we can
it's not-
complete.
It's not your 1 hour, it is the cases that were fixed at the normal. You know, we have fixed other
If
cases.
time permits, my lord, we'll squeeze in. My lord.
No, you might squeeze in. What about we have to squeeze in we need our time also to write the
We
judgment.
are,
You will finish in
yeah,
maybe
my lord,
another
we are
hour.
taxing, my lord.
Ah,
We have one case, your lordship will be dealing with some good
we
numbers.
have got a lot of work also.
Yeah, we understand. We are just
And,
making a prayer, my lord. So that we can finish it, my lord, once
No,
we have
no,
started.
that is all right.
If time
Even the reason we said 2 o'clock was I thought you'd finish. You have taken already.
So even
I
that
think you have taken how much, 2.5
plus
hours in
1
the
hour.
afternoon? And in the morning you have taken maybe,
Morning, actually, we lost 1 hour, otherwise we could have finished it. but-
so you see, no, we didn't lose 1 hour. That was at 12:30. You lost maybe half an hour at the most.
Even,
But you have taken 3.5 hours. You see,
just give me 1 hour, my lord, Monday I'll complete.
Monday to no chance. No chance.
Let's try, my lord, because in continuity.
You can try. We cannot give you time.
No,
We have got to think of our health also.
No, well,
Not only yours.
no,
We'll
I'm
give
not
you, we'll give
imposing,
you
my lord.
time.
I'm asking for accommodation, my lord.
Yes, we'll accommodate. We try to accommodate.
Only Tuesday, my lord, I have some problems, my lord. Then Wednesday. Wednesday, my lord, then let it come, my lord. Huh? What?
Tuesday, we have got, I think that,
Then Wednesday, Thursday, kidney for it.
but I have got it done Monday. I've got that. Wednesday, the Thursday, we can see. Okay, what?
Tomorrow, phone, my lord.
I don't like people like this. Pass some orders so that at least I don't forget.
Let it be on Thursday, my lord, otherwise he has also some problems, my lord. We'll manage.
We'll put on Thursday, let's see. You see, the thing is that when I like to keep some time and then dictate what I've heard,
But
so that we don't forget.
I'll
next time.
summarize it, my lord.
The problem is now, by that time I'll forget. Now
Your lordship will not forget, my lord, taken a long.
Huh?
On Tuesday, not if possible.
No, Tuesday I've got at 2 o'clock, I've got a different bench, division bench.
Thursday will be better, my lord. Thursday? I'll condense it, my lord. And I'll give the paras of the relied upon judgment, my lord. I'll not take time, my lord, for that.
Right on the prayer the parties. I don't know. Okay, there everything again, no? On the prayer the parties list the matter
On Thursday, my lord.
on Thursday, but we might not hear it also. Let's see, depending upon the other matters that are fixed already.
Because, my lord, Thursday will.
Part heard.
Huh?
One,
That's part heard.
We'll leave it like that. No, don't say pattern. We'll see. Because I don't want to have
I
a
request to
democracy
take
sword
about
over my
Thursday,
head.
my lord.
For further hearing,
Huh? You will see on that date.
on Thursday for further hearing, because otherwise,
It will, there's no other bench.
My lord, we'll take a chance on Thursday. How about it? Well, we are obliged for giving a patient hearing, my lord. Sorry for the inter.
Oh, very good.